in item number 28, my lord, the petitioners have filed two affidavit replies, my lord, against our two affidavit opposition. I'd like to call them, my lord.
Yeah, petitioners have filed.
Have filed, my lord. We have received it yesterday.
Hmm.
So, my lord, those eviction matters, my lord, and fresh eviction, fresh encroachment has taken place, my lord.
Okay.
So, my lord, my lord. Oh, listen.
May it please the court. Your lordship, I beg to mention item number 20 on the daily list.
22.
Two. Your lordship, 2 weeks time may be granted to the respondent number 1, 2, and 3 to file their affidavit in opposition. And I've obtained the consent of the counsel for the other side. The matter may be adjourned until then.
Okay. You have informed our petitioner.
Yes,
Okay. MS
Ms. Das.
M. Das.
M. Das.
Learned counsel for the respondent number 1 to 3 has paid for and is granted 3 weeks time to file counter affidavit on behalf of the said respondents. So it is submitted that consent has been taken from the learned counsel for the petitioner to make the prayer. List the case after.
Objection, Your lordship.
May I please, Your Lordship? Your Lordship, I have filed one new IA in WPC number.
IA.
Yes.
Where?
This on 2nd of February, Your Lordship.
In this case,
No,
any
this
of the
is-
matter listed?
No, earlier matter, Your
Huh.
Lordship. One new IA has been filed. Matter has not been listed today,
Okay.
but I pray for the early listing of this matter, Your Lordship.
Next week.
Next.
May it please your lordship, a prayer for listing of a writ petition for admission be kindly be allowed on.
What is the subject matter?
Your lordship, it is regarding illegal construction of house by the private respondents and also the impugn order passed by the respondent number 3, which is Silchar Municipal Board. Much obliged.
For motion item number 1.
Yes.
That private respondent lordship. It is the son of Bipin Chandra Pal lordship. Subsequently he is converted to Islam.
Okay.
That is the reason.
They will file affidavit.
Lordship,
They will issue notice.
no,
also.
notice, yes.
There shall not be any further proceeding in respect of those mutation.
Lordship.
There should be status quo because we don't know adopted or not adopted.
No. He is the son of Bipin Chandra Pal. He is converted to Islam. Lordship.
There is no petitioner.
Lordship.
Because petitioner case is neither natural son nor the adopted son.
No, it is necessary. After inquiry, after hearing, lordship, we have passed this order.
Okay. There is no representation on behalf of the petitioner today on call. Full stop. Hard. MS Z. Hazarika, Learned Standing Counsel, Revenue Department for the respondent number 2 and Mr. N. Goswami, Mr. N. Goswami, Learned Junior Government for the respondent 1, 3, 4, and 5.
Yes.
And MS G. Hazarika, Learned Standing Counsel, Revenue Department for the respondent number 2. Agor para to likhi dibo. Second para. Mr. Goswami, start next. Third para. Mr. Goswami, Junior Government Advocate, who was asked to obtain instruction regarding the events which led the respondent 5 to pass the mutation orders, both dated 22/11/2023, as submitted on instruction that the respondent number 6 was a natural son of late Bipin Chandra Roy, and late Bimala Roy.
His name was Shankar Roy initially.
Uh, and full stop. It is further submitted that the respondent number 6 was earlier known as
Shankar Roy.
Shankar Roy. And later on, after later on, he converted to he adopted the name of Nurul Islam. Full stop. The matter request for Mr. Goswami has submitted that he will bring, he will submit the counter affidavit within 2 weeks' time. Matter could require further examination, issue notice. Returnable. On 3 weeks. Returnable 3 weeks. As Goswami for 1, 3, 4, and 5. MS Hazarika for 2. No formal notice. Yes, petitioner shall take state for service of notice. Upon the respondent number 6 by registered post to AD within 3 working days. MU Mondal and counsel for the petitioner. Yes, Mondal. Now, Mr. Goswami has come up with the instruction that Nurul Islam was a natural son of late Bipin Chandra Roy and late Bimala Roy. Later on, he converted. His earlier name was Shankar Roy. Let him file affidavit.
Yes, let them file
On the
affidavit.
basis of records,
Look,
that mutation has been affected. That is what the version is.
Right.
Then matter would require examination.
Yes, let them file.
You take steps upon respondent number 6.
Well.
Whether he is your real brother or not,
Well,
it will come up later on.
by registered post.
Erase that post. Oh, 4 weeks. Returnable 4 weeks.
Developers.
Mm. The parties it is observed that till the returnable date, the neither petitioner nor the respondent number 6 shall enter into any transaction in respect of the 2 plots of land mentioned indicated herein above.
Obliged.
Item number 2.
Lordship, in this case, I was supposed to obtain instruction. Lordship, I am yet to get instruction.
Well,
Incrementally,
issue notice then.
Lordship.
Heard Mr. R.S. Mishra, learned counsel for the petitioner. And it's MSK Fukan. Repeat for it. Any finance? Any finance?
B. Chaudhary appeared on last revision.
B. Ugoi.
B.
B. Ugoi, it was mentioned. Mr. Kyle, now standing of the CDS, who took some time to obtain instruction on the previous date of this thing, I have submitted that he is yet to receive the instructions. As the method required. Further examination, let notice be issued returnable on 18-3. 18-3. As Fukan for 1, Gal for 2, 3, and 4, and Bugoi for 5 and 6. No formal notice. Extra copies within 2 working days. So all are represented.
Lots of
Having regard to the materials on record, comma, the 2 so-called notices. আগৰ টোৱে আছে, আগৰ para 6 repeat কৰি দিব। So-called notice dated 27/12/2023, right?
Lots, my lord. Item number 3.
My lordship in three, as per my instruction, lordship, provisional release has been lifted, lord. They've been allowed to operate their account, lord.
Well, I may be allowed to obtain some instructions. I have yet to receive instruction, my lord.
Okay. Mr. R.S. Mishra, for the petitioner. K. Fukan, Central Government Council, CGC for the respondent number 1. And Mr. S.C. Kal, Standing Council, CGST for the respondent number 2 to 4. So stop, Mr. What is that order? Otherwise,
Page 22, my lord.
Page 22, provisional,
Attachment of
attachment
the-
was there.
the petitioner's bank account. Main APS 22, sir. Comma, CA number 2 আছে। Maintained with Punjab and Sind Bank,
My lord.
Hemkund Colony, Guru Nanak Market, Greater Koilas -1, New Delhi -10004 was provisionally attached in exercise of the powers under Section 83 of the CGST Act 2017 by an order dated 10/1/2023. As a period of more than 1 year has elapsed, the petitioner has approached this court by the petition seeking on the ground that an order of provisional attachment ceases to have effect after 1 year. Mr. Kal, Standing Council, CST has submitted on instruction that the provisional attachment order has since been lifted. So, sir, Mr. Mishra, Counsel for the petitioner, and the petitioner can now operate the bank account.
Yes.
So, sir, Mr. Mishra, Counsel for the petitioner has sought a week's time to obtain instructions from his client. Lays the case. The prayer made by Mr. So-and-so is allowed. Lays the case on next. When it?
Friday or Monday, my lord.
Monday.
Much.
What is this, Mr.?
That is related to item 4, my lord, that instruction.
Oh, okay. Advanced.
No, I
Advanced. Okay.
have given to the.
Okay.
Item number 4.
My lord, government advocate was directed to obtain instruction.
Hmm.
Personally.
You are Mr. Lutfur Rahman.
Yeah.
Okay, with reference to, I am to inform on the legal complaint petition by Sulema Khatun. Copy enclosed. An inquiry was conducted by a circle officer by report dated so and so on the basis of the petition and the inquiry report of the circle officer. You are Gao Pradhan.
Lordship, yes, my lord.
Now this is the application. Application is there.
Yes, my lord, I have given a copy to that.
Where is the application? Annexer A, last two page. Report of District Commissioner Soraida Sonari, 24/5/2020.
Lordship, regarding this lordship, regarding mutation of that land lordship, particular land, a complaint was filed by Sulema Khatun before the circle officer. And lordship, in that proceeding, petitioner appeared and filed his written statement. And after that, no order, nothing was supplied to the petitioner. And this is the subsequent lordship. And now I came to know, and lordship, after passing of the order on 5/2 lordship by this honorable court, and lordship, honorable court, lordship asked the government advocate not to ensure the status quo, lordship, not to proceed further.
Today is a date for fix. Today is a date
Yes,
fixed.
lordship,
Now, your client has said he would not be attending today as he is leaving for Guwahati to attend a court hearing. I don't know, High Court hearing is not to be attended by the client.
lordship.
Anyway,
Hmm.
this is the complaint. You have received a copy of the complaint.
Yes,
Lordship,
yes,
just
I
now,
have
lordship.
provided.
Just now,
Today
lordship.
morning I have
What
received.
more is required?
Passing of this lordship order, they have not, they issued another notice, but they have not supplied a copy of the complaint, lordship.
Now you have received the complaint.
Now I have received, lordship, I will go and appear, lordship, no problem, lordship.
We'll
Lordship
fix,
will direct-
we'll, Ms. MS Bormon will instruct the concerned
yes.
district commissioner. to
Fine.
Fix another date of hearing,
lordship.
another date of hearing.
And my
Lordship.
advocate may be.
Today,
allowed-
today it is fixed for, today it is fixed.
Lordship.
You'll
And they
appear.
deny my advocate also to appear on my behalf, lordship.
Now I
Then
am
maybe
providing the
lordship.
copy, my lord. Now with that help of that petition, they can appear
This is
before the concerned
in
authority.
detail. This
Yes.
complaint is detail. What is the
Lordship,
basis?
lordship,
Initially, it
I
was
don't know,
not-
lordship, why they refuse to supply me the
Okay,
copy.
that has been, your grievance has been mitigated now.
Lordship,
You appear.
lordship. Through my
My lord.
legal counsel, lordship.
So we'll record that a copy of the complaint,
Yes,
a
yes. my
photocopy
lord.
of the complaint.
Yes.
Lordship.
Uh, on the basis of which hearing has, the proceeding has
was
been
being
initiated,
Lordship.
has been supplied to you.
Right now.
So you know the basis now. Heart. MS R. Gogoi, Learned Counsel for the petitioner. Why ZAD?
Okay. Under this.
MSZ Hajori, Learned Standing Counsel, Revenue and Disaster Management Department, for the respondent number 2, MS
Before I.
M. Bormon, Learned Junior Government Advocate Alam, for the respondent number 3 and 4. Stop. MS Bormon, Learned Junior Government Advocate Assam, pursuant to the order passed by this court on 5/2/2024, has obtained a copy of the complaint submitted by Srimati Sulema Khatun, impleaded as respondent number 6 in this petition, writ petition, before the respondent number 3 on 24/5/2023. A copy of the said complaint, a photocopy of the said complaint has also been furnished to MS Gogoi, Learned Counsel for the petitioner, by MS Bormon. Full stop. The petitioner has approached this court by the instant writ petition with a grievance that copies of the concerned application, on the basis of which the respondent of 4 has initiated a proceeding and notices were issued to the petitioner, were not furnished to the petitioner, despite the petitioner making an application for certified copies of the application, etc. Full stop. As MS Gogoi, Learned Counsel for the petitioner, has submitted that with the supply of a photocopy of the complaint submitted by Srimati Sulema Khatun today to her, the grievance of the petitioner has been effectively redressed, and the petitioner would duly participate in the proceedings before the respondent number 4. Stop. From the instructions placed by MS Bormon, including a communication bearing number CHR/CSS/ENQ/2024, dated 15 February 2024, it appears that the hearing is fixed today for appearance of the petitioner. Full stop. As the petitioner has received a copy of the complaint on the basis of which the proceeding has been initiated only today, comma, MS Bormon shall apprise the respondent number 3 and the respondent number 4 to fix another date of hearing after another date of hearing so as to enable the petitioner to participate in the said proceeding in an effective manner.
Lordship, petitioner will appear lordship to his legal counsel lordship.
Apply before.
Whatever mode is applicable.
Else. In view of the above, comma, there is no necessity to proceed further with the writ petition. And accordingly, the writ petition is closed. Full stop. A copy of the communication bearing number so and so, along with the annexes, is to be kept with the case record.
Bibliography.
Item 5.
May I please your lordship? Now, the matter relates to the prayer for compensation, fair compensation in connection with the land taken up under Mala project matter. Other
Instruction
day,
is awaited, my lord. We need some more time.
well, there is a provision. They are not negotiating us, not discussing us, keeping the matter. They are coming. We said, you don't touch my land unless you pay the fair compensation. They are also, that's why
Without the
project is
consent
also
of the
being delayed.
petitioner, my lord, land.
I
cannot be
already
taken.
recorded.
Yes, yes.
Yes, yes.
As per the scheme, in the
See,
event
that
any
will
of
be
the
taken away.
owners refuses to sell, right,
Yes.
the land, or any of the owners has objected or not interested with a direct purchase through negotiation,
Yes,
the respective land can be acquired through the acquisition process. I have already recorded.
yes, yes.
If they go against it, and if you do not have any consent,
That
Right,
cannot
right.
be done.
Very true.
then they have to acquire it
Acquire
through
it.
acquisition process, for which you cannot stop. If the acquisition process,
I cannot stop.
ha,
Well, there is
if
a,
it is invalid, then it is okay. If they resort to some irregularities, it is okay. Otherwise, if they want to acquire your land, right?
my lord, they can refer the matter to the authority also. There are 64 provision.
They know what they want
That
to do.
stage yet not come, my lord. That stage probably yet not come. Without instruction, I
If
cannot
you
say,
have
my
not
lord.
consented,
Yes, yes.
there is no question of
If he is not consented, then it will be.
taking your land
as
by
per
this
Assam
method.
Mala project provision depicted
It
here.
is basically after negotiation.
The problem is that they are not calling us for negotiation. We are ready to negotiate.
It is up to you.
Yes.
We are not here to make negotiation between you. If they resort to some illegal or inappropriate
Amount.
procedure,
Yes, yes.
then definitely you identify. As on that, there is nothing
Nothing, my lord.
for us. What is this?
They have obtained our signature for bank agreement. That also we have not been able to give.
Huh?
For a bank agreement, they also came to approach us. Signed the bank document so that we.
You have signed.
Yes.
You have signed.
No, I have not signed.
Then they cannot force you.
Yes, very true. Then why the instruction?
Tell your client, if they are not agreeable to the rate they have offered,
Yes, yes.
not to sign any document.
Sure.
At this stage, we can issue notice or we cannot keep this pending.
My-
We thought that if it is possible,
We have.
that
written
what was the,
notes, but
what is the price offered by them?
Yes, yes.
You say it is 10,50,000
No, it is a, yes, they offer.
and they say
6,000.
3,06,000.
6,000.
If the parties do not come to a settlement, then this method will fail.
negotiation will fail, my lord. According
That's
to
all.
the acquiring process will start.
This
My lord,
method will
As per
fail.
law.
Section 26 has given them long scope, my lord, how to determine the price. My lord.
They have not gone to that.
That
Yes,
stage
very-
yet not
They are not
come,
doing
my lord.
anything.
They are not gone. They are trying,
It's
they are
for
saying that they are trying this method. We don't know the legality or validity of this method, but as on date, nothing. আগৰ এটা paragraph first paragraph, Mr. S.C. বিশ্বাস লিখি দিব। Who is for finance? MS? Mr. H. Barua. Council, you be there, Mr. Barua. Nobody from finance is available. There are other matters. Representing Mr. B.U. and Standing Council PWD. For the respond number 1 and 6. You appear. Okay, MS? M does. Okay. M does. Standing Council PWD for the respond number 1 to 6. 1 and 6. MS G. Hajorika, Learned Standing Council Revenue Department for the respond number 2. And MS M. Bormon, Learned Junior Government Advocate, Assam for the respond number 3, 4, and 5.
5.
Agor order to 2 number clarification. Learned Council for the respondents have submitted that they are yet to receive instruction as to whether there is any possibility for any negotiated settlement in respect of the petitioner's patalens. Issue notice returnable consequence. As MS Das for 1 and 6, Majorika for 2, Bormon for 3, 4, and 5. 3, 4, and 5. Have appeared accepted, no formal notice. Extra copies within 2 working days.
Well, item 17 is of same method.
fine.
17. Same area.
Yes.
Eh,
It is Nagaon district, right?
Here, no, no,
Mr. S.C. Visas, Learned Council for the petitioner. Petitioners. M. Das, Standing Council, Public Works Department for respond number 1 and 5. MS M. Bormon, Learned Junior Government Advocate Assam for respond number 2, 3, 4. And MS G. Hajorika, Learned Standing Council, Revenue Department for the respond number 6. Full stop. Learned Council for the parties have submitted that another writ petition, WPC number. Their notice has already been issued.
yes, my lord.
Another writ petition, WPC number 545, stroke 2024, involving similar issues, is ordered to be listed on 18/3/2024. Full stop. The Learned Council for the parties have sought listing of this writ petition also on 18/3/2024. Place the writ petition accordingly on 18/3/2024.
No problem.
Item number 6 with 40.
40.
May I please, Your Lord?
Yes, your name, please.
HP Nepal, Lord, sir.
Okay.
Lord,
Heard Mr. H.K. Nepal,
Lord.
Learned Council for the applicant, and MS M. Bormon, Learned Junior Government Advocate Assam for the respond number 1 and 2. Full stop. The instant interlocutory application has been preferred by the applicant, who has instituted the connected writ petition, WPC number
592.
592 stroke 2024 as the writ petitioner, seeking implement of the following authority, para 3 as a party respondent in the said writ petition. Full stop. It has been averred that due to inadvertence, the applicant writ petitioner did not impede the said authority, who is a necessary party, necessary and proper party for adjudication of the dispute involved in the connected writ petition. Full stop. M.S. Borman, Learned Counsel, Junior Government Advocate of Assam, appearing for the respondent, opposite party number 1 and 2, has submitted that there is no objection if the interlocutory application seeking implement is allowed. Full stop. Having gone through the statements and environments made in the instant interlocutory application, this court is of the considered view that the presence of the proposed party respondent will be necessary for proper adjudication of the issues involved in the connected writ petition. Accordingly, the instant interlocutory application seeking implement of the of the aforementioned authority as party respondent number
5, Lord.
5
Lord.
is allowed to stop. The learned counsel for the applicant petitioner shall file amended cause title
Lordship.
in terms of the notification number so and so within a week before the registry, and the registry after causing necessary correction in the cause title and in the CS, to list the connected writ petition, accordingly thereafter in the motion.
Obliged, Lord.
Item number 7.
In that case, my lord, PNRD name may be shown, so that in that case, main writ petition when listing for motion, PNRD name may be reflected.
Okay. And the name of the learned standing counsel,
May I please, your lordship? My lord, in this matter, Mr.
Panchayat and Rural
Yes,
Development
Lord.
Department
Because
used to be
reflected.
reflected in the respondent side in the of the cause list when the writ petition WBC number so and so is listed in the motion.
Obliged.
Item 7.
My lord, similar matter, my lord. My lord, in this matter, learned counsel, Mr. Prakul Khurana will be arguing to video conference, my lord.
May I please, your lordship? Well, this writ petition challenges the reassessment proceedings under the Income Tax Act, plus whereby by Finance Act 2021, a new set of procedure has been prescribed under the statute, plus under section 148A, which says that before issuance of a 148 notice, the assessing officer, based on an information which he has received, he has to conduct inquiry, give the documents, whatever information, documents he wants to rely to the assessee, call for a response from the assessee, and then pass a speaking order disposing of those objections as to why it is a fit case for issuance of a 148 notice for assumption of jurisdiction to reassess and reopen the case. Plus,
What is 148?
Yes, Malaj, 148. Malaj, may kindly have 148A for a moment, Malaj. This is the new provisions which have been incorporated, Malaj, by Finance Act 2021. Malaj, earlier, there was a Supreme Court judgment, GK and Drive Shafts 259 ITR 19, which laid down a procedure which was not there under the statute, that whenever an assessee is served with a 148 notice, the assessee can call for the reasons and file an objections. And the assessing officer was supposed to and was directed to dispose of the objections through a speaking order and thereafter proceed with the assessment. Now that process, Malaj, in a progressive manner has been incorporated under the statute by way of 148A. Malaj, may kindly have 148 capital A. This is Malaj conducting inquiry, providing opportunity before issue of notice under section 148. The assessing officer shall, before issuing any notice under section 148, clause A, conduct any inquiry if required with the prior approval of specified authority with respect to the information which suggests that the income chargeable to tax has escaped assessment. B, provide an opportunity of being heard to the assessee by serving upon him a notice to show cause, and within such time as may be specified in the notice, being not less than 7 days but not exceeding 30 days from the date on which such notice is issued, or such time as may be extended by him on the basis of an application in this behalf as to why a notice under section 148 should not be issued on the basis of information which suggests that income chargeable to tax has escaped assessment in his case for the relevant assessment year, and results of inquiry conducted, if any, as per clause A. Consider the reply of assessee furnished, if any, in response to the show cause notice referred to in clause B. Decide on the basis of material available on record, including reply of assessee, whether or not it is a fit case to issue a notice under section 148 by passing an order with the prior approval of specified authority within 1 month from the end of the month in which the reply referred to in clause C is received by him, or where no such reply is furnished within 1 month from the end of the month in which the time or extended time allowed to furnish a reply as per clause B expires. So, this is the procedure, mandatory procedure, which.
So, what is 148?
Yes, Manoj. 148 notice. Yes, Manoj. May I read 148, Manoj? Plus 148 says issue of notice where income has escaped assessment. Before making the assessment, reassessment, or recomputation under section 147 and subject to the provisions of section 148 capital A, the assessing officer shall serve on the assessee a notice along with a copy of the order passed, if required, under clause A of section 148A, requiring him to furnish within such period as may be specified in such notice a return of his income or the income or any other person in respect of which he is assessable under this act during the previous period corresponding to the relevant assessment year in the prescribed form and verified in the prescribed manner, and setting forth such other particulars as may be prescribed, and the provisions of this act shall, so far as may be, apply accordingly, as if such return were a return required to be furnished under section 139, which is the regular return, provided that no notice under this section shall be issued unless there is information with the assessing officer which suggests that the income chargeable to tax has escaped assessment in the case of the assessee for the relevant assessment year, and the assessing officer has obtained the prior approval of the specified authority to issue such notice, provided further that no such approval shall be required where the assessing officer with the prior approval of the specified authority has passed an order under clause D of section 148A to the effect that it is a fit case to issue a notice under this section. Then they go on the explanation 1. For the purpose of this section and 148A, the information with the assessing officer which suggests that the income chargeable to tax has escaped assessment means any information in the case of the assessee for the relevant assessment year in accordance with the risk management strategy formulated by the board from time to time. Any audit objection to the effect that the assessment in the case of the assessee for the relevant assessment year has not been made in accordance with the provisions of this act, or any information received under an agreement referred to in section 90 of section 90A of the act, or any information made available to the assessing officer under the scheme notified under section 135A, or any information which requires action in consequence of the order of a tribunal or a court. Then Milaz, explanation 2 would not be relevant for this case, Milaz, but I can read Milaz.
Okay,
Then Milaz, Yes, my lord. Then they say, my lord, so my lord, my submission is, my lord, there are several legal infirmities in this case. My lord, one is, my lord, that the procedure which is under 148 has not been complied with, which I'll show from the order, my lord. Second is, my lord, the necessary material which the CBDT itself has issued guidelines to the assessing officer as to what material has to be provided to the
Now
assessor.
let us see what are the procedure followed as regards 148A.
Yes, my lord. My lord,
Is there any, whether they have completely done away with 148A?
no, my lord, they have gone under 148A.
Let us see then.
Yes, my lord, definitely. My lord, may kindly see the show cause, annexure 3, page 42.
Page
42, my lords. Page 42. Annexure 3.
Annexure
3, my lords. 3. Annexure 3. Now, this is dated 30th March 2023.
that is page 39.
My lords, in my copy, I'm so sorry, my lords. It's page 42 in my copy.
Yes, it is a notice under clause B.
Yes, my lords. They have given me a notice under clause B. My lords,
Did you
and-
receive it or not?
Yes, my lords, I have received it, my lords. I have received it.
Then did you reply or not?
Yes, my lords, I filed my objections to this. My objections are, my lords, annexure 5.
Annexure 3 is the notice.
Yes, my lords. Annexure 3 is the notice. Annexure 4 is some documents which they
These
have
are what are
supplied.
these documents after the notice? This annexure 4, what?
Yes, my lords. Annexure 4 is the.
These are what?
Yes, my lords.
These are
Annexure
part
4
of the notice or what?
Yes, my lords, they are part of the notice.
They are part of the notice.
Yes, my lords, they are part of the notice, are provided along with the notice. And annexure 5 are my objections, my lords.
Annexure 5 page.
Lords, in my copy, I'm so sorry, my lords, it's 73, dated 19th April 2023.
Your reply dated
19th April 2023.
19th April.
19th April, my lords.
Okay, that is annexure 5.
Yes, my lords, annexure 5, page, my lords, it is 19th April. So I filed, my lords, detailed objections to this show cause notice. And I've given specific headings. For my lord's convenience, my lord may see the first heading on page 73. Information material has not been supplied to the SSC company.
Then what happened? This is
Well, this
clause B,
objection.
then you replied.
Yes, my lord. These objections, my lords, which runs into so many pages, my lords, up till page 10 on page 82, my lords, it's 10-page objections. They pass an order without dealing with any of my objection. Through a non-speaking order, one-line order. My lord may see annexure 6.
Annexure 6.
Yes, my lord. This is an order passed under section 148, capital A, clause D.
Annexure 6.
6, my lords.
This is the order.
There's an order under 148, capital A, clause D. So, my lords, from this page, my lords, I'll refer to the internal page, my lords. My lords, it is entire reproduction of my reply. It is a reproduction of my reply.
Is it an appealable order?
No, my lord, it's not an appealable order. It's not an appealable order.
Not an appealable order.
No, my lords, no appealable order. And my lords may see on page 9, my lords, internal page 9.
Sufficiency or adequacy of the region shown is not within the province of a repetition.
I agree, my lords. I agree, my lords. That is not my case.
You are in 226.
Yes, my lords.
Only on few grounds, repetition is
Yes,
otherwise.
that's right, my lords. That's right, my lords. In my case, my lord, there is the proceedings are without jurisdiction. The
Without
proceedings.
jurisdiction, how? Tell me.
Yes, my lords.
How? Without
Yes,
jurisdiction?
yes, my lords. My lords may see. My lords, may I just show this how this my objections have been disposed of first?
No, that is giving regions or no regions, that is one part.
No reasons.
How without jurisdiction?
I'll come to that also, my lords. If I can just
Because
finish up.
jurisdiction is vested.
Yes, my lord.
He has
I'll-
not exceeded the jurisdiction, or he
Yes,
has exercised the jurisdiction not vested in him.
Yes, my lord.
One method.
Yes, my lord.
Exercising jurisdiction, he has passed some given incorrect reasoning, that is another matter.
My lords, I'll satisfy.
Sufficiency of reason, we are not going
My
into.
lords, I am not on the sufficiency of reasons, my lords. I assure my lords, I am not on sufficiency of reasons. My lords, I am on the point that the mandatory procedure 148 AD has not been followed.
Yes, tell me what mandatory procedure. Otherwise, prima facie, clause B, 148A
My lords.
was given or satisfied. Then you have been given the opportunity to reply.
Yes, my lords.
You replied.
Yes, my lords.
And under clause D,
Yes, my lords.
148A, an order has been passed.
My order has been passed without dealing with my objections.
So that is what?
My lords, so my lords,
You're dealing what issue has not been dealt with.
my lords, we see on page 91, my lords. Internal page 9.
Your pages are not telling.
Lords,
Probably, Lordship, he is referring to item number 8, and your Lordship is taking up item number 7. Some confusion.
Yes, my lord. Both are similar methods, my lord.
Otherwise, similar. Some.
I'm so sorry.
Continuation.
Lords. I was informed that it is assessment year 16-17, which is listed
That is
at
item number 8,
7.
my lord.
So I'm
16,
referring to
17 is item number 8.
But if my lords can take up item 8, my lords, I can show it from
I have
item 8.
already taken up 7.
I'm so sorry, my lords. I thought it is listed at the other file is there, my lords. I'm so sorry. I was informed differently. If my lords can take up item 8, my lords. I'm so sorry, my lords, for the inconvenience. I'm so sorry. My lords may have page 91.
Where is the notice first?
Yes, my
Clause
lords.
B notice.
Yes, my lords. My lords, the notice is, my lords, page 42, annexure 3.
Where is your reply?
Yes, my lords. My lords, my objections are annexure 5, page 73. So, my detailed objections are that it is barred by limitation, information not provided, there is no nexus, absence of tangible material, the information don't pertain to me, no income has escaped assessment, I have not entered into any such transaction, lack of application of mind, all those objections, my lords, which I have raised. And, my lords, on page 83 is the impugned order passed under section 148 AD, which starts from page.
What are the points you have taken as regards
My lords, I say yes. my
clause
lords.
B notice?
Yes, my
Main
lords.
point,
Yes, my lords.
which
My main
can be
point.
dealt in a writ petition.
Yes, my lords. Yes, my lords. My lords may kindly see. But I'll show it from my objections, my lords. My lords may see on page 73 onwards.
Income tax, income tax repetitions are before settlements. Lot.
My lords may see.
Limitation, yes.
Yes, ma'am. The first objection, information material has not been supplied to the assessee company. Now, the first objection on page 73 is that.
73.
Yes, my lord, 73. My objections. As in para 2, I have stated on page 74, para 2. Further, your good self has provided a document titled as case related information detail, wherein reference of various statements and fund trail is given. However, your good self has not provided such statements and fund trail mentioned in such document to the company. Para 3. The circulars issued by the CBDT and the consistent observation of the courts in Catena of judgments makes it mandatory for the AO to supply the underlying information which forms the basis of the opinion that certain income has escaped assessment. In the matter of sub-infrastructure, the Honorable Delhi High Court has clearly stated the complete manner in which the AO has to proceed with the reassessment proceedings. Para 5, by way of such instructions, categorical directions were issued to the department and where the reasons make reference to another document, letter, report, such document or relevant portions of such report should be enclosed along with the reasons. Subsequently, the judgment of sub-infra CBDT has also issued instructions so and so to the officers of the revenue regarding the manner in which reassessment notices have to be issued. That the same has been affirmed in the matter of Tata Capital, where the Honorable Bombay High Court has passed the similar guidelines. Para 7, I say, it is humbly submitted that your good self has completely failed to provide the company with all the relevant information, statements and fund trail, based upon which your good self has drawn the inference that certain income of the company has escaped assessment. Your good self has relied upon certain investigation undertaken in the case of Shri Kailash Kumar Patwari and statements recorded therein. However, neither the investigation documents and statements are provided to the company, nor relevance of such random information has been proved established in case of the company. Thus, your good self has completely failed to provide all the relevant information to the company in complete violation of the Act, as well as the established legal principles. Then, para 2, notice is barred by limitation. The company humbly submits that as per section 149 of the IT Act, unless the assessing officer has in his possession books of account or other documents or evidence which reveal that the income chargeable to tax represent in the form of asset which has escaped assessment amounts to or likely to exceed 50 lakh rupees for that year, notice cannot be issued after 3 years have elapsed from the end of the relevant assessment year. In this regard, the relevant part of the section is reproduced here and below. Thus, there is a reproduction of section 149. It says, no notice under section 148 shall be issued for the relevant assessment year if 3 years have elapsed from the end of the relevant assessment year, unless the case falls under clause B. If 3 years but not more than 10 years have elapsed from the end of the relevant assessment year, unless the AO has in his possession books of account or other documents or evidence which reveal that the income chargeable to tax represent in the form of asset which has escaped assessment. Para 3, my lords. It is humbly submitted on page 77, I'm reading para 3. It is humbly submitted that the company has not entered into any financial transaction during the relevant assessment year with the entities mentioned in the dissemination report, except genuine transaction with Mana Trexim Limited, receipt of 29 lakhs, and Akansha Mercantile Private Limited, receipt of 8 lakhs only. Also, it is pertinent to mention that there is no income implication of such transaction as amount of Mana Trexim got nullified during the year and the balance of Akansha Mercantile is only 3 lakhs in the nature of loan. Hence, there is no income component in such transaction. In this regard, the ledgers of both the entities are enclosed herewith as Annexure A and B. Accordingly, it is humbly submitted that your good self has vaguely alleged financial transaction of rupees 1 crore 55 lakhs without any basis, and investigation which is not maintainable. Accordingly, even after considering the maximum transaction amount of 37 lakh only, even if there is any escapement, then it does not exceed 50 lakhs. In the present case, the relevant assessment year is assessment year 1670. Thus, the notice under 148 should have been issued within 3 years of 31st March 2017, that is 31st March 2020. However, in the present case, the notice under 148 has been issued very late on 30th March 2023. Therefore, the notisi humbly submits that the impugned notice is time barred as the alleged escapement cannot exceed 50 lakhs. Then, my lords, another heading, in absence of tangible
So how the
material.
issue this information material has not been supplied to the SSC company, how it is, it has been dealt with?
Yes, my lords. My lords may see the impugned order, which starts on page 83. From page 83 up till page 91 is the reproduction, and the response is on page 91 bottom in one line. Page 91.
91.
Yes, my lords, bottom. Up till there is a reproduction of my objections. Then they say, in response to the above reply of the assessee, it may be stated that all relevant documents necessary to establish the assessee's link with the entry operator so and so has been supplied to the assessee, and that the notice as alleged by the assessee is not barred by limitation. Therefore, the contention of the assessee is not acceptable nor found to be true. So, no reason assigned. And then they say, which is also factually incorrect on page 92 top. However, as prayed by the assessee was accordingly given time till 27/4/2023 to file his reply, but the assessee has not made any reply till date, which is also factually incorrect. Finding and conclusions, then they say the information received from high risk information of inside portal has been carefully analyzed. So, my objection has nowhere been dealt with, which their own circular says. I'll show that circular also, the guidelines which have been issued by CBDT post this amendment, which makes it binding on the authorities as to how they have to follow the procedure of 148A. Meticulous guidelines have been laid down, which are mandatory under 119 of Income Tax Act. And there's absolutely no way my objections have been dealt anywhere. They say, we have given you one more opportunity, thereafter you have not filed any reply, and therefore we assume you have nothing to say. Then Malaj may see, and they on page 93, they go on referring to some other information, other documents, which are not there, even mentioned in the show cause notice. They go to some external evidences on page 93, Malaj may see para 3 on page 93.
Page 93.
Yes, Malaj, para 3. Moreover, in course of the statement of Shri Kailash Kumar Patwari under 132(4), this statement not provided, Malaj, during the course of S&S operations under 132 of the Income Tax Act, 2 desktops have been found at the office premises of Messrs. LS Niketan Private Limited. I am showing you a part of information which has been found in one of the said desktops at the location or through the path so and so. Please confirm the same. Further, please state how you are associated with these companies. Because nothing has been provided there. This reference has come for the first time, which is not part of the show cause notice. And then, they conclude, based on this, on some forensic and financial analysis reports, which also has not been provided, and some posts on page 94, para 2, Malaj may see. Page 94, para 2. Based on the forensic and financial analysis reports and post-search verification, investigation of the case, fund trail has been prepared on the above transaction. From the detailed fund cash trail, it is noted that funds have been transferred through the bank accounts of different entities, including some of the individual accounts, and the same has been transferred through various layers of intermediate. So this is all general observations, Manoj. Nothing provided to me.
Whether these are provided or not, 93?
No, I'll have to take instruction.
Because if it is additional
My lord.
to the show cause or notice under clause B,
We will file
148A,
Lord.
it appears to be prime.
Lord.
This observations, page 93.
My lord.
It appears to be additional document perhaps, or additional information.
But since some factual aspects are there, my lord, we would like to file our affidavit.
And Malaj, if I show on the jurisdiction also, Malaj, this is not all. There are several infirmities. Malaj may see on page 96 for a moment now. Page 96. Annexure 7. Now, this is the notice under section 148. Now, this has been issued by ACIT Circle 2 Guwahati S. John K. Gante. Now, my lord may see section 151 capital A as to how this officer has the jurisdiction. And I'll show another circular, my lords, which is part of my lord's compilation. Lords, under section 151 capital A of the Income Tax Act, my lords, a statutory scheme has been formulated, my lords. This is faceless assessment of income escaping assessment. It says, 151 capital A, subsection 1. The central government may make a scheme by notification in the official gazette for the purposes of assessment, reassessment, or recomputation under section 147 or issuance of notice under section 148 or conducting of inquiries or issuance of show cause notice or passing of order under section 148A or sanction for issue of such notice under section 151 so as to impart greater efficiency, transparency, and accountability by eliminating the interface between the income tax authority and the assessee or any other person to the extent technologically feasible. B, optimizing utilization of the resources through economies of scale and functional specialization. C, introducing a team-based assessment, reassessment, or recomputation, or issuance or sanction of notice with dynamic jurisdiction. Subsection 2, the central government may, for the purpose of giving effect to the scheme made under subsection 1 by notification in the official gazette, direct that any of the provision of this act shall not apply or shall apply with such exceptions, modifications, and adaptations as may specified in the notification, provided that no direction shall be issued after 31st day of March 2022. Every notification issued under subsection 1 and subsection 2 shall, as soon as may be after the notification is issued, be laid before each House of Parliament. So this is plus the enabling section under which the central government has framed a scheme. And
Who is the scheme?
Yes, my lords. It is a part of the compilation, my lords, which must be my lords, provided to my lords separately. Now, the first
You have received?
No, my lord.
Please provide him also
One is copy.
Furnish them a copy, madam.
a copy.
The phone number to log on.
now this is the first item of the compilation, my lords. Page 1, my lords.
Mr. Counsel, also provide a copy to the Standing Council Income Tax.
Yes, yes, my lords. I'll provide that, my lords.
Yes.
Yes, my lords.
What is the scheme?
Yes, my lords. It is on page 1, my lords. It says, my lords, this is the scheme dated 29th March 2022. It says the scheme may be called the E-Assessment of Income Escaping Assessment Scheme 2022. And my lords, on the top it is written, my lords, in exercise of the powers conferred under 151A. This scheme, unless the context otherwise requires, Act automated allocation means an algorithm for randomized allocation that may escape. Scope of the scheme. For the purpose of the scheme, assessment, reassessment, or recomputation under section 147 of the Act, issuance of notice under section 148 of the Act is covered. Shall be through automated allocation in accordance with the risk management strategy formulated by the board as referred to in section 148 of the Act for issuance of notice and in a faceless manner as to the extent provided in section 144B of the Act with reference to making assessment or reassessment of total income or loss of assessee. So, my lords, my submission is this notice at most could have been issued by the NFAC, which is National Faceless Assessment Center, which has been created pursuant to the statutory scheme under 151A as per this notification. And this notification is dated 29th March 2022. Whereas in this case, the notice has been issued on 3rd May 2023 plus after a period of 1 year by an officer. Instead, it should have been issued by NFAC. So it is without jurisdiction. So far, there is a Telangana High Court judgment, which has judgment has quashed the 148 notice on the very much ground, that it ought to have been issued by the NFAC. and not by the officer. That judgment is also part of the compilation. I'll show it. Also, there is one more informative. For some reason, if the department says that no NFAC is not applicable, there is another circular instruction which says who would open the pecuniary jurisdiction has been divided. So for a case where the return of income is less than 20 lakhs in the case of a company, the jurisdiction is with the ITO and not with the ACIT. Whereas in this case, my lords would see on page 96, the notice has been given by ACIT. At most, even if NFAC is not applicable, it should have been given by the ITO and not by the ACIT. Now, that is also part of the compilation, that instruction. I'll show, my lords. That is part of this. Malaj may see this Telangana High Court is passed, is annexed is at seal number 2, page 3, and that is at page 38 of this compilation. That instruction is on page 38. CBDT instruction number 1 of 2011 on page 38. Yes, Malaj. This is page 38, Malaj. Malaj may see, reference have been received by the board from large number of taxpayers, especially from mufsil areas, that the existing monetary limits for assigning cases to ITOs and deputy commissioners, assistant commissioners is causing hardship to the taxpayers, as it results in transfer of their cases to deputy commissioner, assistant commissioner who is located in a different station, which increases their cost of compliance. The board had considered the matter and is of the opinion that the existing limits need to be revised to remove the above mentioned hardship. An increase in the monetary limits is also considered desirable in view of the increase in the scale of trade and industry since 2001. When the present income tax limits were introduced, it has therefore been decided to increase the monetary limits as under. Now, for the corporate returns, income declared mufsil areas, it is ITO up to 20 lakhs and assistant commissioners, deputy commissioners above 20 lakhs. Here, the assessee is a corporate, it's a company. So, it is, if it is the income as per the return of income is up to 20 lakhs, the jurisdiction lies with the ITO, whereas the notice has been issued by the ACIT. So, even it is not within the pecuniary jurisdiction of the ACIT, the officer who has issued this notice, even if NFAC is not applicable.
This is regarding in order to remove hardship.
Yes, Malaj.
Otherwise, what is the is it a statutory notification?
Yes, Malaj. It is, Malaj. It is under section 119. On the top, Malaj would see section 119. And 119 instructions are binding on the income tax department because it has been issued by CBDT. And 119 says whatever instructions and guidelines, circulars issued by CBDT are binding on the income tax authorities.
And attention for corporate?
Malaj, for corporate, it is Malaj up to 20 lakhs. Malaj. Above 20 lakhs, it has to be by the assistant commissioner or deputy commissioner. If the return of income is above 20 lakhs.
Mofussil area.
Yes, Malaj. For metros, there is separate, Malaj. Income declared metro cities, there is a separate column, and at the bottom it is referred. Metro for the instruction shall be Ahmedabad, Bangalore, Chennai, Delhi, Kolkata, Hyderabad, Mumbai, and Pune. At the bottom of this instruction, it is mentioned. And to this effect, there are a lot of interim orders which are also part of the compilation. And there is a recent judgment of Bombay High Court also relying upon the same instruction and questioning 148. That is also part of the compilation as I can show. If I can show now Telangana High Court on that NFAC, because this is my alternative argument, it is without jurisdiction. My primary argument is that it has to be as per the statutory scheme by the NFAC.
Yes.
Yes, my lords. My lords may see the High Court of Telangana judgment. My lords, on page 3 of this compilation. Now, this is on that NFAC issue, my lords, that the notice ought to have been issued by NFAC. The reasoning given by the Honorable High Court is that where a mandatory procedure has been prescribed, so the that procedure has to be followed and no else, nothing else. The relevant paragraphs, my lords, I have extracted in the index. It is para 25, 26, 36. Para 26 would be relevant, my lords, of this judgment. Then, my lords, there are interim orders, my lords, at serial number 3, 4 of my lords, Rajasthan High Court on the considering this Telangana and this circular. These interim orders are there. This, my lords, also, my lords, at serial number 5 is a Bombay High Court interim order on the very issue, my lords, of the NFAC. That it should have been issued by the National Faceless Assessment Center. 6 is also, my lords, an interim order by Bombay High Court on the very issue. Lords, on the pecuniary jurisdiction, the circular, my lords, which I have referred, my lords, on that the judgments, the interim order of Delhi High Court is there, my lords, on page 39. And the judgment where 148 was quashed, Bombay High Court, is on page 41. Ashok Devichand Jain versus Union of India. So this is a final decision by Bombay High Court based on this very instruction 1 of 2011.
Yes.
My lord, since various
Lords have been taken.
so we'll file our affidavit, lordship. Notice may be issued. However, my lord, I am opposing the interim prayer of.
But
the
appears to
petitioner.
be privacy, this notice.
My lord, in fact, this notice, my lord, was
148.
my lord, this notice was issued, my lord, under provisions of 148, lordship. And in fact, my lord, it is in notice for reopening the proceeding, my lord. Nothing has been finalized. And secondly, my lord, this order disposing there, my lord, objection, it was passed on 3rd of May 2023, my lord. And this petition was passed.
Why you are so late?
And in fact,
My lords,
my
we are late, my lords. My lords, absolutely right, my lords. My lords, I am in Jaipur, my lords, and getting it filed and getting it, my lords, it has taken time. And my lords, my mother, in between, my mother was not well. She was hospitalized. So it's on account of the delay.
Appealable order, not appealable order.
notice,
Not an
because
appealable order.
it is only notice, my lord. It's not the
So
final.
far, this order passed under 148A.
No,
Response.
It's not an appealable order, my lords.
My lord, my only submission, my lord, the impugn order was passed on May, my lord, and in fact, this writ petition was filed on, my lord, 3rd of December, my lord, and it was kept defective for 2 months, my lord. So, my lord,
It-
we'll
it-
file our.
there's no urgency.
Yes, lord.
My lord, the urgency.
You filed this petition in December, kept it in defective for 2 months.
My lords, may I submit, my lords? My lords, earlier I was planning to come to Guwahati, my lords, personally. And for my lords, for 2 months, my mother was hospitalized. I couldn't travel. But then, my lords,
Your or your clients?
my lords, because the matter, my lords, was
That
kept
could not
in-
be a ground otherwise.
No, my lords, it is, that's right, my lords. I submit to that, my lords.
That cannot
But,
be
my lords,
taken cognizance of.
That's right, my lords, but here the issue is that my lords, the proceeding itself are without jurisdiction, my lords. And my lords may also see CBDT guidelines on page 57. Now, the manner in which this the proceedings have been conducted and 140-day D order has been passed is violative of the CBDT guidelines dated 1st August 2022 on page 57, my lord. These are extensive guidelines, my lords, as to how the show cause notice has to be issued, how the approval would be taken, how the objections have to be disposed of, what information has to be provided. My lord may see page 57 onwards, my lords. Malajnik, see page
Otherwise
63.
also, you have taken resort to some additional materials. also.
Lordship. In
That
fact,
is-
they are relying on something which is not part of the pleading.
Oh, that is that a privacy.
Lordship. And secondly, my lord, it was passed on, my lord, 3rd of May, my lord. So notice may be
That is-
issued, my lord.
That is also there, but.
Thus, Malajnik, see page 63 for a moment, my lords, for the case comparison.
Yes, yes. Your name, please?
Prakul Khurana.
S. Khurana. What?
Prakul Khurana, sir.
P.
Prakul. Prakul Khurana.
P.
Yes, sir. P.
P. Khurana. Right. Council. To virtual mode, comma. Assisted by Mr.
Mr. P.H. Kaur, my lord.
P.H.
P.H. Kaur, my lord. P.H. Kaur, my lord.
Kaur.
Yes, ma'am.
Your name is not appearing.
Yes, my lord. I'm appearing on behalf of Mr. S. D. my lord.
Lord Council. For the petitioner. And Mr. S. Chetia. Whether this respondent will do for the sole respondent. No requirement of Union of India. Petitioner by this present petition instituted under Article 226 of the Constitution of India. The petitioner has assailed Roman 1 in order dated 3/5/2023. Within bracket Annex 6 passed by the respondent. Under clause D of section 148A of the Income Tax Act, 1961, semicolon, and Roman 2. a notice dated 3/5/2023 issued to the petitioner by the respondent in purported exercise of the powers conferred under Section 148 of the Income Tax Act 1961. Full stop. Mr. Khurana, learned counsel for the petitioner, has submitted that an order passed under Clause D of Section 148A of the Income Tax Act 1961 is not an appealable order, and as such, a writ petition under Article 226 is maintainable. Full stop. It is his contention that in the reply to the show cause notice submitted by the petitioner assessee, it was specifically contended that the relevant information stroke materials were not supplied to the petitioner assessee inter alia. Secondly, the notice was barred by limitation. Semicolon. Thirdly, absence of tangible material in terms of Section 148. Full stop. It has been contended that while passing the order under Clause D of Section 148A, the respondent did not deal with any of such grounds. Full stop. Rather, in addition, the respondent authority had considered certain additional materials which were not additional materials to information which were not brought to the notice of the petitioner assessee at any earlier point of time. Full stop. Fair. It is also submitted that the order under Clause D of Section 148A is not in conformity with the CBTT circular dated 29/3/2022. And in support of such submission, reference has been made to a decision of the Honorable High Court of Telangana in WBC 25903/2022, within bracket K. Ravindra Reddy versus ITO and others, bracket close, decided on 49/2023, where it has been held that after the scheme formulated under Section 151A, it becomes mandatory for the revenue to conduct initiate proceedings pertaining to reassessment under Section 147, Section 148, and Section 148 of the Income Tax Act in a phase manner. Mr. Setia, Standing Counsel, Income Tax Department, has submitted that he would require some time to obtain instruction. And has submitted that a counterview will be filed traversing all these contentions raised by the petitioner. Issue notice returnable on
2003.
20/20/2000. As Mr. Setia has appeared and accepted notice on behalf of all the respondents. Or sole respondent, no formal notice. Extra copy by tomorrow or within 2 working days. Well, it is a specific case of the petitioner that while passing the order, impin order, dated 3/5/2023, in exercise of power under clause D of Section 148A, the assessing authority had considered additional material stock information without bringing those to the notice of the petitioner assessing. As per the scheme formulated under Section 151A of the Income Tax Act, read with CBDT circular dated 29/3/2022. It appears it is evident that a proceeding under Section 147, proceedings under Section 147, 148, and 148A are to be conducted in a faceless manner. So having found privacy composed of in view of the above, this body is considered view that the petitioner SSC has been able to make out a privacy case for an equal protection. Accordingly, it is ordered that till the returnable date, the operation of the imbue notice dated 3/5/2023 issued under Section 148 of the Income Tax Act, 1961 within bracket Annexure 7 shall remain suspended.
I'm deeply obliged. My lords may also make a reference to the other circular, 1 of 2011.
We are on the interim order, Mr. We are not at a full length hearing.
Yes, my lords.
My lord, your
I'm
lordship,
deeply obliged.
asking about the sole respondent, my lord, the Income Tax Department is represented by the Principal Commissioner of Income
That
Tax.
is what I have asked.
Lordship, yes, lordship.
Mr. Setia has raised a issue of maintainability of the writ petition on the ground of non-implement of the necessary party. That is a point. Please take care of it.
I'm deeply obliged, my lord. Now, in the other matter also, it's the same. Same, my lord.
Same.
Yes, my lord. The order
Notice.
dated is also 3rd May.
3-5.
Yes, my lord. 3/5,
And
2023.
Annexer number.
7.
Same annexer.
Yes, my lord.
Only assessment here is different, Lord.
We have not dealt with the assessment yet, Lord.
I'm so grateful.
Item number 9.
May I please, my lordship, my lord, I am extremely sorry, my lord, this matter, my lord, my senior counsel, my lord, R.P. Kakoti sir will address the court, my lord. So he has today some personal difficulties. So he, my lord, directed me to take the matter, my lord, on Monday, my lord. Can it be possible, my lord?
Yes.
Some
Mr.
urgency-
M.U. Mondal, Lord Council put a petitions has sought listing of the petition on Monday. Was Mr. K. Gaur, additional Advocate General, Assam, for the state respondent. Has no objection to a state pair. Place the case accordingly on Monday.
Obliged. Yes.
Item number 10.
My lord, so far item 10 is concerned, my lord, can it be taken after some time, my lord? I have some.
We will be rising, Mr. At 1 o'clock. So sometime will not be available.
Yes, before that, my lord, after some.
We don't know. We'll finish the matter. Thereafter, we'll see.
Item number 35.
Bless you.
There is no representation on behalf of the petition to turn solve. Release the case.
35, lordship. Any past trouble, lordship?
Past over, we don't know today.
Then just. Item 36.
May it please your lordship. Lordship, in this case, the petitioner says approach this honorable court seeking enforcement and protection of our right under Article 19 and 21 of the Constitution of India, which has been blatantly violated by the act of the respondent authority, especially the
Now, why you have made RBI party?
RBI. They are the authority who regulates the business and functions of all these private microfinance institutions.
What is this? You have annexed
Yes.
some circular?
Lordship, I have annexed some circulars.
What
have
is this?
acted in violation of all these circulars. and
What is
also-
this? And let us see the circular first.
Lordship. Circular lordship will get at page number 75. Initially, it was a circular was issued way back in 2003. And from time to time, they are issuing circulars also. Page 75, this was guidelines on fair practices.
So what is the violation?
Violation, your lordship, I have taken one track with the help of the loan given by the respondent number 2 and 3. The loan amount was rupees 27 lakhs and I was to repay an amount of rupees 39 lakhs through EMIs in course of 5 years. I made payment regularly. In between, I failed to make 2 EMIs amounting to rupees 1,98,000. But thereafter also, I have continued giving on the regular EMIs. Only 2 defaults are there, your lordship. Now, without giving any notice, your lordship, when the truck was coming with the consigned goods from Meghalaya towards Guwahati, through the agents, your lordship, they have forcefully taken away the truck in between, and they have also collected all the goods contained there. Cement bags were there, your lordship. When I have repeatedly approached them that I'll make the payments, so kindly release the truck, but through use of muscle power and force, your lordship, they have taken away the truck. And
We'll issue notice.
lordship. And I have only one interim tell your lordship that they shall not dispose of the truck, your lordship. Because this is one of the tactics they take and then they dispose of, your lordship.
On which judgment you are relying?
So far, lordship, this procedure that they have adopted, your lordship.
We'll
Yeah.
see. We'll see about that because you have said that when the vehicle was coming from Shillong to Guwahati, your vehicle was taken forcefully.
Forcefully, lordship.
Now, otherwise, they have power to repossess the vehicle even for one installment.
In accordance with law.
In accordance with law, what is the law?
The law basically, Lordship, it is the SURFACI Act.
What is the law?
The SURFACI Act, your Lordship, which
SURFACI Act.
Lordship, recovery of loans.
Mr. SURFACI Act is available to an NBFC, is applicable? First, tell me that. If you have not examined that issue, then don't examine that issue in the court.
It is applicable, your Lordship.
Which provision? NBFC. These are non-banking finance company in the private sector.
Lordship.
Which is where? Bank means bank.
At clause number M, your Lordship, section
Clause
2
number?
M, section 2M. Subclause 4, your Lordship, section 2, subsection M defines financial institutions. And as plus subclause 4, your Lordship, any other institutions or non-banking financial company as defined in clause F of section 45I of the Reserve Bank of India Act, which the central government may by specify as financial for the purpose of this act, your Lordship.
So central government has notified Tata Finance Limited as the financial institution. Central government has to notify a private party as a financial institution for the purpose of clause 4. Then only they can resort to SURFACI provisions, right? Otherwise, it is either a hire purchase agreement simpliciter or a loan agreement simpliciter without application of SURFACI. There is one. You have to satisfy me on that. That SURFACI is applicable. Secondly, law is settled. A repossession of a vehicle can be taken by the financier in accordance with law.
In accordance with
Right? Now, what has been explained and interpreted by the Supreme Court, that what is in accordance with law?
I will refer to the judgment.
Otherwise, if RBI does not come into picture,
Lordship,
then your petition is not maintainable because of Sagar Thomas. If RBI has no role,
Lordship,
then your petition is not maintainable in view of Sagar Thomas and all other decisions. That is why I have been asking you all these queries.
Lordship,
You have made RBI a party,
Lordship,
and secondly, you have made Tata Motors Finance Limited and branch manager Tata Motors Finance Limited.
Lordship.
I have already held. So, any interference on my part will be against my decision.
Lordship,
So, explain me how RBI comes. Where is the scheme?
Lordship. Scheme I have just, even they have also formulated their own scheme, which also, at
They
page
have
number
formulated
75.
a different that they are a private sector player. They are completely private sector player. They have nothing to do with state, public sector. Now, your circular, RBI master circular, the exercise of powers,
Page 80, your Lordship.
See first 81. In exercise of powers conferred by section 2135A, section 56 of the banking regulation. Now this Tata Finance does not come under Banking Regulation Act. Chapter 3B of the Reserve Bank of India Act. Yes, that can be examined. Section 30 and section 32 of the National Housing Bank Act. It does not come. Reserve Bank being satisfied, has issued these guidelines. Now here, short title is Mr. Loskar.
Lordship.
These directions shall be called the Reserve Bank of India Regulatory Framework for Microfinance Loans Directions 2012-22.
20.
Now come to clause 3. A definition of microfinance loan. A microfinance loan is defined as a collateral-free loan given to a household having annual household income up to 3 lakh. So, how much you have taken?
I have taken loan 27 lakhs.
Does it come?
No, it is the loan to a household having annual household income up to rupees 3 lakhs. It is the person who is claiming the loan.
Basically, it is low income 3.2.
Lordship.
All collateral free loans provided to low income households having annual income up to 3 lakh.
Lordship.
If you are a low income, then I don't know whether you can obtain a loan for 27 lakh truck.
That is, they are giving a lordship.
Okay, we don't know. I am not just, I have glanced
yes.
through. But you have to satisfy me.
Lordship, so far the
We can issue notice at this stage.
lordship, kindly interim period maybe.
No interim period.
Otherwise, your lordship, they may dispose of the vehicles. It is in their custody till today also. Let it be there, your lordship, till the returnable date.
Otherwise, I am not satisfied. I don't.
Lordship, so far as the
Which decision?
actions of the respondent number 2 and 3 is concerned,
That core decision,
lordship,
Supreme Court core decision, Paramjit Kaur or whatever.
no, your lordship,
All these have been later on explained
lordship.
by Tejas Bench decision that the financier has the power to take possession. Third, Mr. Amit Loskar, Learning Council for the petition. The petition has alleged that the respondent number 2 and the respondent number 3, from with which the petitioner had entered into a loan, page 16, loan dash come dash hypothecation come dash guarantee agreement, annexer 1. For the purpose of purchasing a vehicle within bracket truck registration number NL-01 stroke D dash 5559.
It should be AD, your lordship. AD.
AD in the year 2019. Full stop. The petitioner has alleged that the petitioner has stated that the said loan the agreement was executed for obtaining financial facilities for an amount of rupees 27,38,000, and the petition was required to repay a total amount of rupees 39,12,337 through a number of equated monthly installment EMI at rupees 66,334. Post on. It is the allegation of the petitioner that the respondent number 2 and the respondent number 3 have forcefully repossessed the vehicle without serving any prior notice, without serving any repossession notice, any prior repossession notice. When the vehicle was proceeding from Meghalaya to Guwahati,
Lordship.
only on the sole ground that the petitioner had defaulted in making payment of 2 EMIs, right?
Lordship.
Issue notice returnable in on so and so date.
2003.
The petitioner shall take steps for service of notice. Of our particular. The petitioner has submitted that such an action is violative of the directions of the respondent Reserve Bank of India. Issue notice to the respondents returnable on so and so.
2003.
A petitioner shall take steps for service of notice upon the so and so where it proposed with AD within 2 working days. Post of the issue of maintainability of the writ petition is kept open for consideration on the
If interim
returnable date.
relief is not given, they may dispose of the truck, Your Lordship. They may dispose of the truck, Your Lordship.
You serve also by Dusty also, in addition.
Lordship.
অকমান আগুৱাই দিব।
Obliged.
To respond number 2 and 3.
Obliged.
Respond number 2 is from which place?
3 only, and we can.
Respond number 2 is from which place?
Mumbai.
Okay, respond number 3.
11-3.
Dusty, huh? Compliance affidavit within 2 weeks.
Obliged. Lord, I am sorry, my lord, the item number 35, my lord, is a part of the same series, my lord, and I could not appear, my lord, 35, my lord. 30. May I please, your lordship? My lord, the matter relates, the petitioner is the proprietor, my lord, of a, my lord, micro scale industry, which is, my lord, manufacturing and, my lord, distributing this packaged drinking water, my lord. My lord, we have all the requirements which are required under the law to operate the business. And, my lord, what has happened, my lord, they have issued a notice. The respondent, health department, my lord, may be pleased to find the notice of, my lord, the food at page
Health Council,
35, my lord.
showing or not?
Name is showing, my lord.
Where are they?
My friend also.
Yes, please.
My lord, may I draw my lord's attention to page 35, my lord.
Yes.
Lord, it says.
I'm looking at the original one, page 37.
My lord.
We all always, most often find typographical mistakes.
My lord. During the inspection today at your premises, it is found that you are carrying on the food businesses without following the general requirements on the hygienic and sanitary practices under the provision of the Food and Safety Security Act 2006. Henceforth, in issuing the notice, you are hereby directed to comply with the below mentioned improvement measures with the immediate effect. The directions must be met during the next inspection. My lord, these are.
It was in July.
My lord. 2/7/2024, my lord. And
We are
thereafter.
in February 2024. 2/7 or
No, my
2/1?
lord, it is 2/1/2024, my lord. 2/1, January, January. Now, my lord, and thereafter, we have also made a representation before the, my lord, food, to the honorable designated.
Whether this
My lord.
BIS
Yes,
certificate
my lord, yes, my lord, therefore I beg to draw. my
or
lordship.
FSSAI license.
My lord, my lord. My lord may be pleased to find my lord. Food and safety, my lord, is at page 30. Registration certificate, my lord. My lord.
Registration.
My lord. These are the requirements, my lord.
Registration certificate.
My lord.
This is registration.
Yes, my lord. And then, my lord, this is the registration certificate and application for renewal of registration certificate can be filed, my lord. We have also done that. And my lord may be pleased to find.
Now, then why he is saying that apply for FSSAI license? This is certificate. Is there any difference between license and a certificate?
That we have gone through the provisions, my lord, but that is not in the FSSI, my lord, Act, my lord, which
Or
holding, my lord.
what is this BIS certificate?
That is, my lord, Bureau of Indian Standard, that
Yes.
the ISI mark or something like that, which we are required to maintain. But my lord, for this
For
type of,
whether these conditions
my lord,
are condition precedent or condition subsequent to
um,
operate an industry of
my lord, it is a condition,
20 liter,
no, my lord, the, as per the
20 liter packaged drinking water.
my lord, as per this provision which I have gone through, my lordship can also go through under the act, my lord. There is no direct, my lord, involvement of this, my lord, that this type of industry is required, my lord, that the food and that the BIS registration is not, my lord, required.
No, registration is one thing.
No, no,
License
certificate.
is another thing.
Certificate, my lord, that certificate.
Say FSSR.
Food and safety security.
License.
My lord. And my lord, we are running the business since long, my lord, and there is no
Running
complaint.
the business is okay, but running the business without compliance of the provisions is
That is
another one.
that is correct, my lord. That is correct.
Show
my
me
lord,
why it is not required.
my lord,
I have not gone through this big book. You are a
no, my lord, I have the Bear Act of this Food and Safety Standards Act as well as the, my lord, this Bureau of
it
Indian
contains definitely this packaged drinking water.
packaged drinking water. That's what
Standards are laid down as far back as in 2000 because
my lord. My lord, we
because
are,
when I was on the other side, I did litigation. So I know.
my lord,
So where it is laid down?
under the, my lord, Food and Safety.
That was in other previous act. This is in 2000.
My lord, the Food and Safety Section 13 is relevant, my lord.
Mhm.
Improvement notice.
The only ground I took that at that point of time that
My lord.
my seizure was earlier in point of time before standard has been laid down.
Laid down. That is correct, my lord.
Right. So in 2000, it was laid down. Where is that? Packaged drinking water, it is laid down already. There will be a table.
But my lord, recently the government has come up with a policy in the, my lord, central government that they are making some relaxation for this type of industries, my lord. That
Show
has,
me.
my lord, that has not yet been implemented, but my lord, news are.
Yes, Mr. Huya.
Lordship, there is a regulation under Food Safety and Standards Prohibition and Restriction on Sales Regulations 2011.
11.
Point number 17. If
Licensing and registration of food business.
Lordship, it is in page number 863.
860.
Restrictions relating to conditions for sale.
800.
863, Lordship. Point
63.
number 17.
What is the name of the regulation? First tell me.
Is restrictions relating to conditions for sale.
No, no, a regulation.
Restrictions?
No, no.
What is the full name? Full name?
Food Safety and Standards Prohibition and Restrictions on Sales Regulations 2011.
1 minute.
But my lord, they, in the notice, it has not been for that reason, my lord.
Prohibition. Okay, 2011, yes. Clause?
17.
17.
Hmm?
2.3.13.
Hmm?
2.3.1. Lordship, it is 2.3.14.
2.3.1.
3.14. It is relating to restrictions relating to conditions for sale.
Once again, you please name the regulation.
Lordship, it is Food Safety and Standards Prohibition and Restrictions on Sales Regulations 2011.
That I have.
Lordship.
But
Lord-
2.3 is prohibition and restriction on sale of certain products.
Yes.
Lordship.
Yes. Then
Then,
what are the subclauses?
subclause 17, Lordship. Lordship, if first. Oh,
Vaccine.
Ground New 9. Registration to have.
What are the licenses you have got already?
Milord, licenses I have got already, that the trade license is there, then Milord, this food and safety at page 30, Milord, registration
Page
certificate.
30.
Milord. Food Safety and Standard Authority of India.
29. Food analyst.
No, Milord, page 30, page 30. Milord, my sample has been analyzed, Milord, and that analyzation report says the sample is chemically satisfactory with respect to the tests carried out.
Okay, 1 minute.
At page 29, Milord, by the Health Department, Milord. Yes, European standard.
Okay, this is your food analyst report.
My lord.
Okay, then
my lord, the next page,
registration
the
certificate.
registration certificate in the
Okay.
FSSI, my lord. Then, my lord,
Registration certificate item is beverages
My lord.
excluding dairy products.
my lord.
Okay.
Then this with them registration, my lord, annexure 4.
That is another thing.
Another thing, my lord, it is by the Ministry of Micro Small Industries, my lord. Then this notice came, my lord.
Okay.
And my lord, I even, my lord,
1 minute.
made a representation that if any lapses is there on my part, my lord, that I will.
Now,
My lord,
2.3
my lord,
regulation. Mark কিমান হ'ব page 2?
item 35, my lord.
একদম পুৰণি আমাৰ। হা? 20. Regulation, restriction of sale.
আমাৰ এইটো কিমান
এক মিনিট।
establishment কেতিয়া হয়? Registration টো?
Restriction of sale. পুৰণি আমাৰ নতুনবোৰ আহাই নাই নেকি? Restriction of sale. Prohibition and restriction of sale. 687. 687. 687. Clause 2.3.14. 2.3.14.
It is drinking water, no?
Okay. 17. Yes, Mr. Bhunya.
My lord,
BIS. It is a condition precedent,
my lord, that's
not
why
a condition subsequent.
President, my lord. My lord.
No person shall manufacture, sell or exhibit for sale packaged drinking water except under the Bureau of Indian Standards certification mark. You
No, I have
satisfy yourself.
No, my lord, I have done
We'll
from
issue notice at this stage.
my lord. Or my lord, can we
This is
we will apply before the authority, my lord. And the authority will, my lord, take a call on my BIS certificate, my lord. Until
Did you apply?
Yes, my lord. I have made a representation. And my instruction is that I have applied for all the requirements, my lord. That BIS certificate, initially they have not asked for, my lord, but suddenly it has
No,
come
it
up.
is a condition precedent
Correct,
otherwise.
my lord. That is
And there is a act BIS Act.
That statutory prescription we have to
And
follow.
that is a statutory authority.
My lord.
And there must be some prescribed form also.
Yes, yes, my lord.
This kind of representation will not do.
Yes, my lord. Or my lord, in that form, I will, my lord, or if my lord in the temporary measure, if my lordship allows us to operate the
No,
business, I can understand.
which is prohibited,
My lord, my lord,
expressly prohibited,
expressly,
because it is for human consumption.
my lord. I can understand.
That is difficult.
But my lord, my chemical
We
examination.
cannot
has been-
ignore.
My lord. That examination report is there, my lord.
No, food analyst is right. I have also seen
My lord.
that is already there at page 372.
My
I
lord.
have examined that this is also a condition precedent. 372 in
Yes,
this
yes.
book. There is a standard laid down for packaged drinking water. It is in Food Safety and Standard, Food Product Standards and Food Additives Regulation 2011.
My lord.
And clause 2.10.8, packaged drinking water other than mineral water. Standards have been laid down. I have also examined your color, taste, everything I have checked. Food analyst has given the report. Yes, it passes the test.
It will help to get the other requirements, my lord.
But yes, for obtaining this BIS mark.
My lord.
But so far at this stage, it is a bit difficult. Only ground is that 14 days notice that has expired.
My lord, that.
The ground you have taken perhaps,
My lord, they have not.
mandatory 14 days notice.
My lord.
They have not acted within 40 days.
No,
Within 14 days.
in
The
one
14
of
days
the-
have expired.
In one of the petition, they have acted, my lord.
I think it is better to, we can issue notice at this stage.
My lord, my lord.
Hard. Mr. A.R. Bhuiyan. Learned counsel for the petitioner. And Mr. In two of the cases, no coercive action has been taken till date.
No, my lord.
Let it be like that. Mr. B. Gogoi, Learned Standing Counsel,
35 karo, okay. Course of action one.
Health and Family Welfare
Yes.
Department for the all the respondents.
No, my lord,
for the
except the,
respondent number 1 to
except
6
yes, 5, 7 and 8, my lord, government will.
and Miss S. Sharma.
4 to 8. No, no, food safety, I'm not.
Learned Unigram Advocate Assam for the respondent number 7 and 8.
I'm not.
Post up.
They help them.
Agree by issuance of a notice dated 2/7/2024 within brackets annex 5. Comma, the petitioner has prepared the instant petition to stop. The petitioner is in the business of manufacture and sale of 20-liter packaged drinking water. Full stop. By the same notice, comma, the petitioner has been asked to produce, has asked inter alia to produce BIS certificate and to apply for FSSAI license. Full stop. Mr. Gogoi,
My lord, one thing, my lord,
standing counsel.
there is a provision for appeal, my lord, under 32, 32(4).
32(4).
My lord, this
Such a
page
big act.
33. Page number 33.
4.
30.
No, we are having a different book.
It's another Food Safety and Standards Act, section 32, subsection 4. It says, my lord, if somebody is issued any notice under section 32(1), he has the, my lord, the right to go for appeal.
It was designated official satisfied the head.
Only the maintainability part, my lord.
Respect to any.
Any improvement notice. Here, improvement notice has been issued.
Okay.
That maintainability part may be kept open.
But there is a procedure.
Lord, sir.
Designated officer after serving a notice, has to apply to the Commissioner of Food Safety for imposing the prohibition.
My lord.
And if the Commissioner of Food Safety is satisfied on the basis of the application of the officer that health risk condition exists with respect to any food business, then he will impose the prohibition. And the prohibition has not, the stage of prohibition has not
Given, my
reached.
lord, on the, against the improvement notice.
Which
Yes.
one?
4. 32(4). Any person who is aggrieved by an improvement notice. Here improvement notice has been issued.
32?
4.
30?
32(4)(a) is improvement.
32(4).
Yes, ma'am. 32.
32(4). Improvement notice.
Yes. Commission. 32(4)(a). Prohibition 34.
Yes, and this is an appealable.
Otherwise appealable, my lord.
I think you better take recourse to this.
Lordship may give a time frame, my lord, he must appear, my lord, otherwise, with appeal. Only thing, my lord, there is a time limit given in
Right.
subsection 5, 15 days.
Right.
That part lordship can take care of.
How I
Yes,
can
yes.
take care?
No.
Now, in all these text matters now,
Yes. In
If
that
the-
case, my lord, that maintenance part may be kept open, my lord. That may be reflected in the court's order. Because these are notices of
January.
January.
is there any provision for condonation?
My lord, that probably is not there because.
That if that is not there, it is very difficult.
Yes, yes. Ma'am. And it is a special act otherwise.
Special act. Things have gone stricter and stricter day by day.
Lordship.
Who is agreeing? Yes. What is this section 32(5)? What is the interpretation? The period within which such an appeal may be brought shall be. Please read carefully.
Yes. Period within which
15
such a-
days from the date
15 days from date
on
when
which
notification was served.
notice of the decision.
Notice of decision.
No, it says appeal. The appeal is otherwise general. Or it says 3 grounds on which my lord can. be
3
served.
grounds
Yes.
may be appeal, but period within which such an appeal may be brought shall be 15 days from the decision.
It will have to be within 15 days. From the date
Decision.
of decision.
Notice of.
It is not speaking about notice, improvement notice.
Maybe, my lord, the date on which they have taken a decision to issue the notice, my lord.
Notice of the, 15 days from the date on which notice of the decision.
Notice of the decision was served.
Because see, subsection 2 and subsection 3.
15 days. Date on which the notice of the decision was served on the person desiring to appeal.
It contains some decision of suspension,
Yes,
cancellation.
subsection 2 says suspension. In case, my lord, if fails to
Subsection 2
improve-
says about suspension.
My lord.
Subsection 3 says about cancellation.
My lord, 3 says, my lord, even after suspension, if he fails to, my lord, improve it, then, my lord, next option is, my lord, cancellation. So then, in that case, a notice will have to be given, then decision will have to be taken.
Notice has been given.
No, notice to improvement has been given.
Notice to
Thereafter
improvement.
suspension, then again, my lord, final.
Cancellation.
Yes, cancellation. my lord.
Now, what is this? Then we have to read. The period within which such an appeal may be brought shall be A, 15 days from the date on which notice of the decision.
My lord, yes, some.
Decision is one, improvement notice is another.
Lordship.
Can you clarify? If he has the time to still an appeal,
My lord, that part, yes. Because
it
4A
does.
says, my
If
lord,
he has the
improvement-
provision for appeal, at least, because find out from your authority.
Lordship.
Notice on the decision, my lord, maybe the part.
That may be the suspension or maybe the cancellation.
But my lord, 4A is very clear otherwise. It says, my lord, any person who is aggrieved by A, an improvement notice may appeal to the commissioner of food.
But whether the time limit
Yes,
is,
some, my lord, yes.
because see, 5A, there is a time limit,
Yes, my lord,
but it is about notice of the decision.
of the need, serving of notice of the deed.
But in respect of improvement notice, there is no specific time limit.
Lordship.
If
Yes,
still, but it is an appealable.
It is appealable.
It is an appealable notice.
I understand, my, on that point, my lord, yes. Where
Just on that
limitation will
point.
come if, my lord, if improvement notice is put to challenge. Oh, yes, my lord. That I will-
Otherwise, it is a condition precedent. We have already found. If by appeal, if you get some breathing space, it is up to you.
I can understand.
Then you can pay for interim and not to suspend,
My lord.
right? If there is, Mr. Gogoi, there is no time limit to
Yes. in
file an
that case,
appeal
Lordship,
against
yes.
an improvement notice,
Yes,
then they'll file appeal.
yes, yes. Yes,
I think that will be better.
My
My
lord.
lord.
Otherwise,
But here, my lord.
we are not in a position to pass any interim order.
No coercive
lord,
action. No coercive action till, my lord, my friend come up with it.
That
My lord, so far as the first two items are concerned, it will cover by this particular order regarding clarification of, on, my lord, 30-5. Last case, my lord, WPC 791, penalty order has already been issued as a.
Penalty
What
order
I can say is, it is 437. A petitioner has been directed to close the business within 3 days. So there, my lord, this
10
15
January.
Yes, my lord. 10 January 24.
And Mr. Priya, when did you receive it?
Yes, yes, my lord. My lord, receipt date, my lord. I have to take instruction, my lord, for exact date.
If that is also an appealable order,
This will be appealable order, apparently, because it says, my lord, final order, within 3 days you close it.
Monday,
Monday.
take your instruction,
Not
will provide opportunity if there's against improvement notice, one can file appeal and there is no time bar, no time limit, as it privacy appears, then you file it. Otherwise, it is a condition precedent.
My lord.
You cannot operate. Express prohibition. Okay. A.R. Bhuiya and the B. Gogoi. Yes, Monday?
Monday, my lord.
Last standing of the health welfare department. On the request of so and so, Monday, 35, 37, 30.
My lord, as we have not been suspended yet, my lord, till Monday, status quo.
Mr.
But that I will confirm. Today itself I will confirm.
No further actions. Mr. Gogoi will answer.
My lord.
I will.
Obliged, my lord.
Item number 39.
Yes, you have restructured the repetition.
My lord.
Okay.
Lordship, only thing is that, my lord, three orders are in my favor, my lord. That since 1985, my lord, I'm holding the position.
Yes, Mr. Bora.
The material.
Exonia land. It is Exonia.
Yes, government land.
No, no, they are government lands.
Yes, yes.
Different categories of government land.
Yes.
According to the petitioner, it is Exonia, annual lease land.
Really.
If it is so, then it has to comply with 18.3, not 18.2. And that has been already held by the Revenue Board.
My lord, my lord.
I think where is the
My
decision?
lord, page 26, my lord.
Page
26, my lord.
26. Page 28. Page 28, Mr. Bora.
Yes, paragraph number 6.
Does the appellant have the bona fide claim of right for the land in question? Hence, the appellant cannot be evicted through summary proceeding under Rule 18(3).
No.
It should be 18(3).
18.
So, this demolition,
The subsequent demolition has taken place.
already some demolition took
Some
place,
part, my
but
lord.
at this stage, Mr. Somaria, only
No, my lord,
only status quo.
This pair is only status quo only. This pair is status quo.
Oh,
that's
is it so?
Lordship, one thing is
Is
that,
it
my
so?
lord,
Otherwise,
Lordship, may I pray one thing, my lord? The something is going very, my lord, doubtful. My lord, what happened that the authorities now acting in such a manner, my lord, they are trying to capture the property. My lord, the record may kindly call for the incident that has taken place 7 and 8, my lord. There is necessary, my lord.
we'll see, Mr. Somaria, as on that status quo.
My lord.
Heard, Mr. S. Somaria. Not a counsel for the petitioner. Mr. Bora, you are for?
3 and 4, madam.
Okay. Message Sharma, Learned Junior Nominee Advocate Assam for the respondent 1 and 2 and 5. 1, 2, and 5. Mr. S. Bora, Lion Standing Counsel,
GMC. madam. GMC.
GMC, for the respondent number 3 and 4. Full stop. The
Well, in the 6, 7, 8, has been named person by name.
We take a statement.
6, 7, 8. If notice, lordship issue notice, then only otherwise not. 6, 7, 8.
it is the categorical stand of the petitioner that the petitioner is in possession of a government plot of land. Any DAG number, pata number?
Yes, my lord.
Yeah.
Where is that?
My lord, 2 formula. I have space.
Where from? Where from? Who can see?
My lord, can you see the order reflects? Page, my lord, 66 my lord.
Page
60, my lord.
60.
Yes.
Okay. In possession of a land measuring 1 katha 10 lesas, covered by government DAG number 1124, situate at village Sohor Ulubari, part 1, Moja Ulubari, Guwahati Revenue Circle, within bracket subject plot. Since the year 1981, and the said government plot of land is Exonia land. The petitioner has stated that when at an earlier point of time, petitioner was served with an eviction notice, the Assam Board of Revenue in case number in its judgment dated 27/7/2001 within bracket annexer 2 passed in case number 198 PA within bracket K bracket close stroke 1997 and observed that the petitioner had a bona fide claim of right in the plot of land in question, and the petitioner could not be evicted through a summary proceedings by issuance of a notice under Rule 18 within bracket 2 of the settlement rules framed under the Assam Land and Revenue Regulation 1886. Full stop. The petitioner has alleged that no notice
No notice, ma'am.
without serving any notice even under, Rule 18(2), the house of the petitioner
Partially demolished, partially.
standing on the subject plot was partially demolished in an eviction process carried out on
8, my lord.
8
8 to
2024.
23.
Agreed thereby, the petition has approached this court by the instant writ petition. Full stop. Issue notice returnable on 33. As
See,
Mr.
just after 15.
As Mr. So and so and MS so and so appeared accepted notice, no formal notice. Extra copies within 2 working days. The petitioner shall take steps for service of notice. The petitioner has alleged high-handed action on the part of the respondent number 6, 7, and 8.
7, 8.
Huh?
Yes, 6,
The petitioner.
6, 7, 8.
6, 7, and 8. 6, 7, and 8.
Yes.
Stating that they had acted without any authority of law. Observe notice. The petitioner shall take steps for service of notice upon the respondent number 6, the respondent number 7, and the respondent number 8 by raised their posted AD within 2 working days. Full stop. In view of categorical assertion by the petitioner that the subject plot is Actionia land and having regard to the fact that the Assam Board of Revenue has already held that the petitioner could not be evicted from the subject plot by way of summary proceedings under Rule 18 within bracket 2 of the settlement rules framed under the Regulation 1886, and there was no prior eviction notice before carrying out the eviction exercise on 8/2/2024, comma, it is observed that till the returnable date, comma, the respondent or the authorities shall not undertake any further coercive measure, and the status quo as on date shall be maintained.
Deeply.
Item number 10, finding item.
Yes, please, your lordship, my senior is on legs of.
Now your senior is on legs.
Yes.
Yes, what to do?
Yes, my lord, the legality and validity of the my lord voter list and the notice for holding the election and exam are challenged here, my lord.
When is the election?
My lord, 19th February 2024.
19 February 2020. Close by. Because we'll be rising. Tomorrow?
Tomorrow.
Mr. M.E. Mondal, Learned Counsel for the petitioner is present. MS.
YA Kunyak on behalf of MD.
YA Konyak.
On
Learned
behalf of MD Bora.
Counsel. Appearing form is
MD Bora.
M. Bora.
MD Bora.
MD Bora, Learned Standing Counsel, Cooperation Department has sought listing of the case tomorrow. Place the case accordingly tomorrow. Papen Chandra Roy.
May I please, your lordship? Your lordship,
Yes.
this matter may be passable for time being.
Passed over for the timing. When? After 1 o'clock.
Before that release,
Yes.
or maybe fixed
No
on
counter.
Monday.
No, not yet.
No counter. Compensation. Land compensation. What is the allegation here? Non-payment of adequate compensation. Non-payment of adequate compensation, meaning thereby you have received some compensation.
Yes, Your Lordship. Yes, Your Lordship.
Then,
Your Lordship, my senior has the briefing.
yes, Mr. Talukdar, if they have received compensation and they are not satisfied with the amount of compensation,
They have to go to the deputy commissioner for reference.
who is your senior?
SB Chaudhary.
Okay. On the prayer of Miss
ZR Majumdar. ZR Majumdar.
Zedar Mojumdar, learned counsel appearing for Miss S.B. Chaudhary, learned counsel for the petitioners. List the case. Did you? Mr. B.J. Talukdar, learned senior counsel appearing for instead by Mr. P.K. Medi, learned counsel for the respondents.
No,
Submitted that.
Not all the respondents. maybe. Respondent number 5.
Respondent number 5. Hmm? We are simply adjourning it. I submitted that the repetition has been preferred, agreed by non-payment of just compensation for the land belonging to the petitioners, which were already acquired through a land acquisition proceeding, and as such, the repetitioners should approach the alternative forum. Yes. Why this is maintainable? Compensation received.
No, my lord, compensation has not been paid. This is the, my lord, the grievance of the petitioner is, my lord, regarding non-payment of adequate compensation.
No, one thing. No compensation is one thing, and non-payment of adequate compensation is another thing. Is it a
Yes.
case of absolute non-payment?
Absolute no, non-payment. My lord, the forest department has constructed brick wall, my lord, on the western side of the patta land of the petitioner, my lord, without even giving notice, my lord.
Then
After
if there is no
verification.
payment,
My lord.
then some response should be there.
After joint verification,
but-
respondent number 4, my lord.
Petitions, okay,
issue an
okay. Now there is
official,
no counter till date.
official communication. my
MSD
lord.
Hazarika, lawyer standing also revenue. Department for the respond number 1.
Your lordship may issue notice, my lord, because
Notice is already issued, returnable in 6 weeks on 39/2022.
yes, my lord, we have taken, steps,
Uh,
my lord.
Mr. Forrest, you are the main culprit. They are saying that you have demolished everything.
Annexer 8, your lordship. my inquiry.
Annexer?
8 at page 45. This is from the divisional forest officer. It was a lease, probably. Lease for 20 years.
So it was a forest land,
Forest.
according to the forest department.
My lord, they
And
said,
it is within reserve forest area,
my lord, it can.
but still, patta has been issued.
That patta probably, it
Ah,
was, they
20
say
years.
20 years.
So it is periodic patta.
Normally periodic patta is 30 years.
No, 20s are also there. So the district commissioner has issued patta.
No, sir.
And
Probably-
accordingly,
probably that was
after
the-
getting periodic patta, they may not be aware of the coordinates, longitude,
They probably.
etc.
My lord.
They have constructed. They have constructed the structure on the basis of periodic patta. Forest department is asking for cancellation of patta. Yes, it is barred otherwise. Once forest has been declared as reserve forest in 1984,
84.
any issuance of periodic patta is barred,
After that is barred.
but you have still issued.
Whether that land falls there or not, that instruction,
We
I
don't
do not
know.
have any instruction.
I think deputy commissioner should clarify. And forest department also, Mr. Gogoi,
My lord.
you bring this notification also with coordinates,
My lord.
government notification.
84.
Then we can ask for at least field inquiry.
That is-
They have been issued periodic patta.
Normally in this.
Right or wrong, they have been issued a periodic patta by the deputy commissioner, another arm of the government. Right? And they have constructed. They may not be aware of this,
Yes, man, FCA.
all these coordinates.
Let us bring it.
Okay. It appears from the letter dated 8/9/2016, within bracket annexer H, comma. That the stand of the forest department is that the periodic patta land of the petitioners is located within the territorial, within the territory of Elasij, ELASHIJAR, Elasijar forest, comma, a reserve forest declared by a notification dated 9/3/1984. Full stop. On the other hand, comma, the petitioners have alleged that, have contended that periodic patta in respect of the land in question had been issued in their favor for in the year, for a period of 20 years, from 2009 to 2029, by the district collector, Kokrajhar. Full stop. The respondent authorities shall bring their respective stance through counter affidavits. Full stop. Release the case after 4 weeks for filing of counter affidavits by the respondent authorities.
Okay.
Hold it.
Item number 12.
Yes, I will.
My lord, this is a matter relating to National Highway. And at the time of demolition of part of the building, one part of my building was also hampered. But that was not surveyed. Therefore, on the last occasion, my lord, 9th of August 2023, this court has passed an order saying that PW, whether any survey was there or not. And today I got the instruction, my lord, survey was done and report is also there. And some money has been awarded regarding that portion.
Who has awarded?
Awarded means calculated, not awarded, calculated.
By whom?
By the PWD, sorry. And order is at
But
dated
otherwise, your building is not within the right of way.
that is correct, but the common building, my lord. My lord may,
A common building, some the damage which might have been caused
that is correct. To
because
that
of
extent.
demolition of your cousin brother's building.
Yes, to that extent only.
What is the amount? 419.
Only.
Yes.
Third
Was
page
it
is-
forwarded to? Yes, who represents competent authority?
Gulaghat, Deputy Commissioner.
Yeah, I'll have to take. it
Yes,
separately.
because
I do not have the copy.
come to, do you have the affidavit of the NHIDCL?
I know.
I think, Mr. Talukdar, you should go to the affidavit of NHIDCL.
That,
Provide
yes, I will be.
I know.
That, in that matter, they only said that.
Just to minutes.
I'll take these two
Please,
copies.
please, no, have a look at the last 2 pages.
Last 2 pages of the affidavit.
Huh? Oh.
Of the affidavit.
There is a picture before
Yes,
in the
yes.
penalty made. I think one portion
One portion was
of the building, that is his cousin brother, that was taken over,
Right.
acquired. The
Right.
remaining part is petitioner's building, which is not within the right of way. But because of this demolition, there might have been some damages.
Damages to the building.
Right,
And that was-
otherwise, next picture, last page. His building, your name is?
Farooq Hussain.
Farooq Hussain, extreme left top.
Yes.
His building is not within the right of way. So
So I
for
think-
acquisition, he will not be entitled.
Well,
But so far as damage,
demolished portion of the building.
because of the demolition of his cousin brother's part of the same building,
Yes.
there might be some damage. So that has been assessed according to executive engineer.
Yeah, we send it to the PWD for
No,
assessment.
it has been sent to additional deputy commissioner, Kala, competent authority. Hi, Mr.
DK Nath.
BK Nath, Learning Council for the petitioner. Any CGC? Mr. PK Medi, Learning CGC for the respondent number 1. Mr. BJ Taludar, Learning Senior Counsel, assisted by? Oh, you are 1? Okay. Assisted by Mr. PK Medi?
Myself.
Or M. Bormon? Junior Government Advocate Assam for the respondent number 2, 3, and 4. And MS? Madam, you are not there.
Actually, on the last occasion, my lord, as per the order dated,
She-
9th of August,
Spotlight.
9th of August 2023.
You have to make them party.
Direction was given actually, because PWD is under that competent authority.
No.
Kindly
Competent
please-
authority is central government. Appointed.
My lord, but the
PWD cannot be, Mr. Nath.
My-
Don't
but the
expand
payment-
the definition of competent authority. MS? Akiralda. Learned Standing Council, NHIDCL for the respondent number 5 and 6. Mr. Nath, Learned Council for the petitioner, has placed a copy of a letter number so and so dated 12/9/2023 of the executive engineer whereby he had forwarded a valuation estimate in respect of that part of the building belonging to the petitioner to the additional deputy commissioner Gulaghat, who is the competent authority land acquisition appointed under section 3A small a of the National Highways Act. Mr. Nath has further submitted that despite such valuation estimate, no compensation amount has been assessed and disbursed to the petitioner. Mr. Talukdar, Learned Senior Counsel appearing for the respondent number, who has appeared also for the respondent number 3. has submitted that he would obtain instruction as regards the present status of the claim made by the petition.
Present status of the thing.
First of,
Status of-
as to whether any steps have been taken, whether any step has been taken on the said valuation estimate forwarded by the executive engineer so and so to him. Raise the case after 2 weeks.
So just
Or it is fixed by the office.
well, additional deputy commissioner is not renamed as additional district commissioner.
Item 13. I've been told that your lordship is rising at 1 o'clock. So therefore, this matter, my lord, urgency is there. They are enjoying stay order. Let them enjoy. Next week, your lordship will fix.
Next week.
But the records from the ACR, ARC has to come. Because that is the crux one.
Who is the corporation?
Cooperation, my lord.
It's
B.K. Roy Chaudhary, counsel for the petitioner.
Who will inform, my lord, if your lordship may.
SK Talukdar is there for the corporation.
Second record. That's it. Hold on.
And Mr. B.D. Das, senior counsel. Appearing for the petitioner. Respondent number 4.
Yes.
For the respondent number 4 are present. Later, the next week to the party. 23 or 26? 26.
26, yes.
Lord, the
Earlier the
ARC
case
will
on
produce the
26
record.
to 2024, full stop. Learned Standing Council Corporation Department shall make endeavor to produce the necessary records from the office of the Assistant Registrar of Cooperative Society.
I think register.
From the okay. Necessary records of proceedings.
Records, my lord.
Records of
Yes,
proceedings.
Proceedings.
Okay, records of the proceedings. List the 26. The interim order passed, shall continue till the
Similarly, item 16, my lord. Your lordship may fix it, my lord. 3 days.
What is 16? Okay, we'll go one by one. We'll sit for further 10 minutes.
Yes, yes.
I was sitting at 2 o'clock.
May I please, your lordship? Lordship, matter is relating to the compensation for acquisition of land. So we filed a writ petition.
You have received compensation or have not received?
Received but not adequate. So my lord, one thing is that there is a provision under section 3G5 for appeal. So after filing this writ petition, I have referred an appeal to the competent authority. And by an additional affidavit, I submitted that appeal. Only a simple prayer, my lord. This appeal may be disposed of within 30 days. This, your lordship, may kindly please issue such.
Sir, counsel, there is another problem now. To be resolved or not? Where is MS Bormon or yes, Hazarika? Issue is resolved or not? That appointment of a retired,
Perhaps not.
perhaps not.
My knowledge, as yet.
That Ashok Bormon issue.
Instance only emitted from the central government.
Because by passing an order to dispose of your arbitration case will not bring any result because there is no arbitrator at present. So we are dealing with those issues. So we'll wait for some few days. Whether appointment of arbitrator is made or not, it is to be made by the central government. Okay, Mr.
ATM Hussain.
ATM Hussain, petitioner. M. Bormon. Mr. Talukdar, you appear for? 1 to 5. 1, 2, 5, 6. Mr. B. Talukdar, BJ Talukdar, Senior Counsel, stay by MS M. Bormon, Learned Junior Government Advocate Assam for the responding number, and MSG Hazarika. Standing Counsel, Revenue Department for the responding number 126. CGC, no. Mr. PK Medi, CGC for the respondent 7, and Mr. Talukdar, RK Talukdar. Market holder, standing house and NHI is still for the responder of 4. 8. You have been implemented. Are present, learned counsel for the parties have sought for 2 weeks' time to apprise as to whether any arbitrator under section 3G5 has been appointed for the project in question. Please the case. After 2 weeks later.
Pledge, my lord.
Item number 15. Lordship, here there was a settlement and we have paid the amount. In between, there was delay in payment. Actually, the settlement amount per month was 17 lakhs and we paid 12 lakhs in between for some time. Thereafter, they charged the interest on that. We have paid that interest and we have cleared the entire amount. Now they are again demanding 48 lakhs.
Have they
And-
appeared?
Lordship.
Have they appeared?
Yes, Lordship. On the
Who
last
represents Canara Bank?
M. Sharma or B. Sharma.
Their names are appearing.
Yes, Lordship.
Then maybe it is beyond 1 o'clock.
Yes, Lordship.
SN Damali learned counsel for the petition is present as the learned counsel for the respondent bank authorities is not is found absent today on call. Release the case after a week on a day to fix the documents.
Item number 16.
Yes, what was yes,
they
all
brought the
was supposed
instructions.
to obtain instruction.
They have brought the
Yes,
instructions.
Okay. We'll consider on some other date. Not possible.
Next day.
We need us. Senior
Short
counsel,
pattern.
assisted by HR does. Petitioner, MS, PR Mohanto, learned counsel for the respondent of court are present. MS Mohanto has submitted that instructions in deference to the order dated 10/1/2024 have been received. So stop. Please the case on 26.
26 minutes.
My lord, I am for respondent number 5.
Mr.
J. Borman, my lord.
J. Burman, लिख दियो. 26.
Item number
You
18.
retained that.
My-
You retained those records.
My lord.
Item 18.
Yes, anything.
Lordship, we have not received any instructions so far, the up-to-date instruction.
So
Otherwise,
basically,
Lordship,
in the
the-
case of no instruction.
Lordship, otherwise the cabinet has already approved the sanctioning of the amount.
There is
Three
no
installments.
representation on behalf of the petitioner today on call. Post of Mr.
U Sharma on behalf
U.
of
Sharma, learned counsel appearing for
Mr. K. Kaur
K. Kaur and standing counsel Panchayat and Rural Development
for
Department.
respondent was 3.
Has paid for further 3 weeks time to obtain up-to-date instructions regarding the status of the process of release of remuneration in respect of the petition. So
Thank you.
is the case after 3 weeks.
Item number 19.
Please, Lord. In this matter, I'm appearing for the private respondent number 9.
9.
9, Lordship. The matter is, Lordship, the writ petition at the very outset is not maintainable because the writ petitioner says she is the adopted daughter of someone, but kindly, Lordship, come to the certificate of birth that has been annexed, my lord. That will, I mean, in fact, make the very writ petition non-maintainable.
What is the relief?
Relief, basically, what has happened is, Lordship, if I may submit, the respondent number 9 is the husband and the sole legal heir of the deceased Sona Borua. Now,
Or
the
to issue next of kin
in
certificate.
certificate and
Right.
some inquiry into the Lota Hill police station case.
And to show cause as to why Dotasil police station case number against respondent number 9 is not investigated.
Yes.
Thirdly, provides security.
Yes, my lord.
So, sole of next of kin certificate It is a notified service.
Already issued in favor
uh,
of the respondent number
If
9.
aggrieved, there is a provision for appeal.
Yes, Lordship.
Secondly, police station case, they found the case as a civil nature.
Lordship.
If the petitioner is aggrieved,
Lordship, 2 civil suits have already been
if
filed by the
petitioner
petitioner.
is still aggrieved, they can
Yes.
approach under 156(3).
Lordship.
And security, we don't know. There is no representation on behalf of the petitioner
And-
on call.
For a moment, Lordship, I'll
We'll not
just,
examine further because in the absence of the learned counsel for the petitioner. MS ZAD, anybody? MS M. Bormon, learned junior government advocate Assam for the respondent number 228 and Mr. A. Sharma, learned counsel for the respondent number 9.
9.
Present. As the petitioner is found not represented today, release the case after a week. Mr. Sharma, learned counsel for the respondent number 9, has raised the issue of maintainability of the writ petition.
yes, Lordship.
After a week, the issue of maintainability is left open for consideration. Is kept open for consideration.
Yes.
Items 20 and 21.
Obliged, Lordship.
Yes, your disputes are there.
May it please your lordship, before lordship may kindly adjourn the matter for the day, lordship.
Your retaining wall dispute.
Yes,
My
lord.
lord.
My lord, the fact,
How we can resolve?
there is a, my lord,
Go to the mediation.
my lord, just, my lord, very briefly, may I just, my lord, explain the facts. So, my lord, the fact herein is that, my lord, that the other side and the plots are, my lord, adjacent plot. And he has, my lord, constructed his building, my lord, without taking any precautionary.
I remember
My
from your
lord, lordship
earlier
has not-
deliberation.
Remember.
There is
Now-
a slope,
Yes, my lord, my lord.
something like that, with
Yes, ma'am.
gradient.
My lord.
Somebody's plot of land is on the upper
Not upper, my lord.
upper side.
No, my lord, not upper, on the same line.
This is a case,
Is it a plain land?
My lord, not.
I
plain.
don't think so, Mr. Counsel.
No, my lord.
Don't represent.
No,
It
my
is
lord.
the hill, lordship.
Ah,
It's the hill.
that I remember
Yes,
with a
lord.
gradient.
Yes,
Lordship,
my
this
lord is,
matter
my
will
lord is
require
correct.
some time to.
not-
Mr. Counsel,
My lord.
don't say that. I remember.
My lord has remembered, and my lord, there is
It
some
it
confusion.
is with a gradient. It is in a slope.
My lord.
Somebody's plot of land is on the upper side and somebody's plot of land
No,
is
my-
on the lower side.
No, that is not the fact, my lord. Adjacent, my lord. On the same line, my lord,
I have seen picture, Mr.
my lord,
Counsel.
my lord.
Don't say that now.
On page 39.
Somebody
my
has
lord,
annexed.
My lord, yes, my lord, there is, my lord is.
Mr.
sign of-
Gogoi, why you are forest?
Yes, my lord.
It is forest.
No, my lord. We have brought in, my lord. First allegation was the petitioner says that no permission was given by us. Then we conducted joint verification.
Because of hill cutting.
Yes, my lord.
Oh.
And then the honorable court says you have no business out there because it's a private land.
This boundary wall
Yes, my lord.
is between two private plots of land.
Private.
We might have no business here.
Yes, my lord.
Yes,
This
my lord.
friend can't.
My lord, that another
Mr.
significant.
BK,
Nothing.
My lord,
both will be imposed
no, my lord.
something. BK Das, learned counsel for the petition in WBC 6133/2023. And if you, in the process, if you cut the hill, then come up with proper
My
instruction.
lord.
If hill cutting is indulged by the parties,
It is.
come up with proper
Yes.
instruction.
No hill cutting, my lord. The police.
We are not making any final opinion,
Lordship,
madam. And MS N Begum, learned counsel for the petition in 118/2020.
Well, I mean, my lord,
Have sought for listing of the cases after 1 week, list the cases accordingly after 1 week. Mr. Tagaligo, Mr. D. Gugui, learned standing counsel forest department. And MS M. Bormal, learned junior government advocate Assam for the state respondents are present.
Much obliged, lordship.
Item number 23.
Okay. Yes, Mr. Chauhan.
My lord, some articles of the petitioner have been seized by the police, my lord, without giving any, my lord, seizure list or any document, my lord. My lord, petitioner submitted several applications before the authority, my lord.
So who is to respond?
My lord,
Which is the authority to respond?
my lord, page 34, annexure F, my lord.
Who is the authority? Respond number 3. Tell me. R.S. Chauhan, Learned Counsel for the petitioner.
4, my lord.
In charge, he is under respond number 3.
Yes, my lord. Maybe.
M.S. Bormon, he is alleging something. M. Bormon, Learned Junior Government Advocate Assam, for the respond number 1 to 4. At present, full stop. It is the allegation of the petitioner that articles were seized from the plot of land of the petitioner.
Yes.
Without any seizure memo.
Yes.
And thereafter, are kept in the custody of the respondent number 3 and 4.
Yes, 4.
M.S. Bormon, Junior Government Advocate Assam, shall obtain instruction from the respondent number 2 to 3 as regards the allegation that articles were seized from the plot of land of the petitioner without any seizure memo and kept in the custody of the police station. Release the case after 3 weeks.
Obliged.
Item 24. This is regarding the issuance of Christian marriage license.
License. You're not getting license.
No, Your Lordship.
Our instruction is still awaited, Lord.
You're still awaited.
Lordship.
It can be.
How much?
It can be disposed of, Your Lordship, directing the.
Today, no time. K. Mira, petitioner.
2 weeks, Lord.
Z. Hazarika, Standing Council, Revenue and Disaster Registration Department, 1, 2, 3, and 5.
Lordship.
M.S. M. Bormon, Junior Government Advocate Assam for the respondent number 4 at present. M.S. Hazarika has sought for further 2 weeks' time to obtain instruction as regards issuance of the Christian marriage license in favor of the petitioner. The praise the Lord is the case on.
Public.
33.
Public.
Deeply awaited.
Item number 25.
May it please your lordship. Lordship, this matter was that, my lord, that due to the inadvertent mistake
They
of
have
the
filed.
person. My lord, they have not filed, my lord.
Where is Kyle? Okay, it is beyond 1 o'clock.
Maybe, my lord, may I pray for a date, my lord? By then,
Friday,
he will
Friday.
file it, my lord.
Friday.
My lord, on 6th, my lord. 6th of March, my lord.
Okay. Mr. H. Betal, Learned Counsel for the petitioner, is present. The respondent
120
authorities.
Yes, 120
have not
filed their affidavit.
filed their counter affidavit in reference to the order dated 24/1/2024. So release the case on 6/3/2024 for filing of counter affidavit by the respondent number 1, 2, and 3.
I do like
Item 26.
Remy Paul Notch. Yes, Lordship. Mr. Sharma? That payment, family pension or something like that. Compassionate family pension. The petitioner is not getting from the date of her husband.
Lordship.
I think
Lordship,
you were asked to obtain instruction.
Yes,
to-
yes, Lordship. We are waiting for the same, Lordship.
Otherwise, scheme is clear.
During that period, yes, Lordship. But we have not yet received any instructions.
Petitioner is saying that she is entitled for pension.
From the date of the effective date, Lordship, she is claiming, Lordship. Otherwise, Lordship, but we have not yet received any.
Her husband died on 5/9/2017.
Lordship.
And the scheme came into effect on 1/4/2017. So prior to that.
Prior to that.
Okay. As sought for by the Land Council for the parties, release the case on 6/3.
Lordship.
Item 27.
May please, your lordship. Lordship, 2 weeks times may be given, lordship. Some instruction are still awaited, lordship.
You are not satisfied with the details of all the police cases?
Satisfied, lordship.
Then why you are pursuing anything more?
No, lordship, but as our already.
By the
given, but
order,
some
I have given
time-
all the details of all the 9 police cases.
Yes, lordship.
Mr.
P.K. Basu.
P.K. Basu, the counsel for the petitioner, has prayed for listing of the case, has sought for adjournment of the case. Full stop. The praise allowed is the case after 2 weeks, on a date 2 weeks by the office.
No problem.
Item number 28.
28 minutes.
Someday else.
Someday else, but my lord, only concern is, my lord, the fresh encroachments are taking place in swelling day by day, my lord.
No, these are all absurd.
No, my lord, this is a picture, my lord.
No, it makes.
This is
We are not going
Go by
to the, all those today,
My lord, 22 might be fixed, my lord, maybe. 22.
not 22.
We are
We can
29th.
fix it on 23.
23, my lord.
And
20.
thereafter we'll decide.
My lord,
Can it be on
23.
29?
20
No, my lord, 23. My lord. We're fixing
29.
contempt also, my lord.
29, no, I have
23, my lord.
fixed the series on 29.
Let it be 23.
Fixed a long series.
23, my lord.
23 will proceed thereafter.
My lord, 23.
And the interim order may continue.
Chamber pastor yourself. Sought for by Mr. P.S. Vehicle and Civil Council for the petitioner and Mr. D. Gogol and Standing Council and Environment and Forest Department. Release the case of 23.
My lord.
Interim order pastor yourself.
Always.
This is item number 41.
Any interim order?
Yes, lordship, there is an interim order. Kindly extend it.
Okay. MS
Tin Long on behalf of the Tuldas.
T.
Tin Long,
Tinglong.
Tinlong.
Okay, Land Council appearing on behalf of Mr. Didas, Land Council for the petitioner. Sought for listing of the case on another date. Full stop. List the case after week. Date to be fixed by the office. The interim order passed earlier shall continue till the next of listing. Any other interim order to be extended?
Lordship, may I please, your lordship, in item number 44, lordship, as per Lajma court order dated 14 to
We'll not
15 to
do
lord-
that exercise.
No, lordship may fix it for admission, lordship.
Huh?
Kindly. Lordship may fix it for admission.
No, we'll defer, we'll
Complete, lordship. There is
we'll
some
not
urgency,
exercise
lordship.
that Mr. Sharma today.
Lordship, there is
For-
some urgency, lordship.
Next day, review next week.
Lordship, this.
All the cases will be fixed on next week. All the cases which are left out today will be fixed on fixed date in the next week.
My lord, if I may most humbly pray, my lord, item 26, I couldn't get in here in time. We received the parawise comments, my lord. We file a counter affidavit.
Okay, MS Sharma, you are appealing for
Yes, my lord, the High Court.
as a state council or high court?
High Court.
Standing council GHC has submitted that necessary instructions have been received and a counter affidavit will be filed within 2 weeks' time. 6 Street.
Deeply obliged.